2-1. Can I have counsel identify themselves for the record, starting with the Commonwealth?
Good morning, Your Honor. Michael McGee for the Commonwealth, and with
Okay, Mr. McGee.
DA Jennifer Hickman.
Morning.
Okay, Hickman.
Morning, Your Honor. Rosemary Petrie on behalf of Miles King.
Okay,
Good morning, Your Honor. Jaleesa McDonough for Mr. King.
thank you.
Good morning, Your Honor. Nicole Scavicio for Mr. King.
All right,
Good morning, Your Honor. Susan Costa on behalf of Ms. Brianna Gardner.
okay. How are we going to proceed? We have, Mr. King, Ms. Gardner, you can be seated if you want. How are we going to proceed?
Is there a couple of motions to quash that I think we probably have to deal with first?
Okay.
My understanding is that 2 of the 3 witnesses that we subpoenaed are here. My understanding that former Trooper Proctor is not here, and I think his attorney wanted to address the court.
All right. That's really not what I was asking about.
Oh, sorry. He was my first witness, Judge.
That's okay. The question I have is, everybody agrees that this is an evidentiary hearing.
Yes.
And the issue at the evidentiary hearing is, why wasn't quite a pile of discovery turned over until April of 2024 with trial scheduled in September?
Right. April, May, June.
April, May. Okay. All right.
May I be heard?
Yes, of course.
Thank you, Your Honor. Preliminarily here, much has happened since the motion to dismiss was filed, including a reduction in bail.
Yep.
The defendant has posted it. The trial is no longer on the trial list. At no point has counsel supplemented, and I've been counsel for King, has supplemented her motion. As I stated in my opposition, there's no analysis or specification about what documents are material or exculpatory or in any way, no identification of documents at all. And what I would ask the court to prevent simply a fishing expedition here with various witnesses is for counsel to identify why or what documents prevent her client from having a fair trial that were produced late. I think that at a bare minimum, we should narrow the issues as to what documents here we're talking about.
So I understood the motion to dismiss to be addressing both the issue of prejudice and also the issue of a flagrant violation of the obligations to produce discovery.
Right.
And I also saw in the papers, which I did read this weekend, the suggestion that there was prejudice, but it was rather conclusory.
Correct.
In the defense papers. And there was a suggestion that there was one witness who was no longer available that they learned of for the first time, or some information about a witness that they learned about for the first time in this discovery. I don't know, we may get into that. But at a minimum, there's a question about the flagrant nature of the failure to produce discovery. That's what's alleged, and I understood this hearing to be largely addressed to that, why stuff wasn't produced as it was required to be produced under Rule 14. And I think that there can be oftentimes an appropriate sanction for that, depending on how egregious the failure to produce was. And in this instance, there's a lot of stuff produced at the last minute, and I understand that there have been a number of accommodations made as a result. The release of the defendants, I don't know, was one of the defendants out already?
That would be Ms. Gardner.
Ms. Gardner was already, so Mr. King has been, and then the continuation of the trial to allow counsel to deal with some of the newly discovered or newly revealed information. But I don't think that eliminates the need for the hearing.
I'm just at a loss for what is new to counsel, what is and what is prejudicing the defendant.
Here's one of the problems that I have in looking at the papers. Here's one of the problems that I have in looking at the papers is to some extent everybody is talking past each other. I don't have a full picture of what all the evidence was that was produced in 2021. And I don't know the extent to which the stuff that was produced in 2025 was new,
Right.
was peripherally related to things that were produced earlier, were things that the defense would have necessarily known existed but didn't ask about, or that really have to be independently investigated and should have been produced a long time ago. And understand the scope of Rule 14.
I understand.
So I think I have to have a better understanding of that, and that is a multi-pronged question.
I agree.
Right? Okay.
If I can just respond, we did take the time to print out all the late discoveries. I did it both on paper, and I know you're a computer guy, so it's also a USB drive.
It's not helpful to me. Okay, I appreciate the fact that you printed it. At some point, we'll get to admission of documents, and in this hearing, we'll get there. We'll get there. You know, it doesn't help me to get that without analysis of what was produced before and without. So you know,
here's our problem, Judge, is that it appears that this discovery is rolling. Okay.
Is what?
Rolling. So when we got the discovery in April, we were outraged. When we got the discovery in May, we were more concerned. When we filed the motion to dismiss, we were dealing with the April and May disclosures. There have now been June disclosures and now July disclosures, and as I understand, more disclosures coming from information, Judge. So I'm concerned that what's before the court right now is not the full picture of what's happened with respect to the late discovery. And so I think that in terms of analyzing the discovery, we've spent the last month and a half just trying to get through it, Judge. Because what's happening, can you give me those? The Commonwealth is making allegations that we got certain documents. And so we have to go back to our original filings when we have them and say, what did those documents look like? And we have so many examples, Judge.
That's exactly what you need to do
Right.
in order to be able to demonstrate to the court that there is prejudice. And so my threshold question is, how are we going to do this hearing? Are you intending to introduce every document that was produced during the notice of discovery 1, 2, 3, 4, 5, and then stack up next to that the stuff that was produced in 2025 and force me to go through it?
No.
So, so the question is, how are we going to do this in a logical way to either demonstrate prejudice or for the Commonwealth to demonstrate absence of prejudice, or are we just going to analyze this on the grounds that all this stuff should have been available to the Commonwealth long ago, should have been produced long ago, and there should be some sanction because it was obvious that this stuff should have been produced a long time ago, and it was by neglect or worse that it wasn't produced. So how are we going to get our arms around it?
Well, I thought about that, Judge, since we filed the motion and we knew the hearing was coming. One of the first things I did is go through every single document that the Commonwealth claims we already had. And I can tell you that I pulled those documents, I've compared them to the documents that were produced in 2021, and many, many times, Judge, they're not the same document. They're the same look, but it's not the same document. There are additional facts in the stuff that we just got in 2025 that weren't available in 2021. And so what I planned on doing was going through what was introduced in 2021, going through what was introduced in 2025, and pointing out for the court what the differences are in those documents. To refute what the Commonwealth is saying is that they were the same document.
As a practical matter, okay, the two sides or three sides could sit down and do that. And it would eliminate the need for hours of testimony. You could sit down and say, this is a different document than what we got originally. There might be some disputes. Your work product maybe have some mistakes in it. The Commonwealth's work product may have some mistakes on it. You probably resolve 99% of it and put in an agreement that document number 236 is different. Document 237 is the same, but it's got some additional handwriting on it, whatever it is. And that could be stipulated because that's just a comparison of two different things, right? Looking back, that would establish the baseline for what's new that's been produced in 2025. And then we can talk about prejudice from those documents, from those new documents.
I understand that, Judge. The other thing that I would ask,
excuse me one second more, it would also focus the analysis on what went wrong in the process. Okay, if all this stuff should have been produced in 2021 or 2022 or whatever, by identifying exactly what's new, we could pinpoint why it happened. Okay, and we get a better understanding of why it happened.
To a certain degree, Attorney Hickman already identified what was new. When she took over the case in January of 2025, she started to do, I think what she called a deep dive into the case. And when she did it, she discovered information that wasn't turned over. The way that she produced her discovery notices is she would tell you, I'm giving you a different copy of this because there's a different page. Or she'd say, previously produced on such and such a date. But there's something different about it that she feels like she needs to produce it now. So she's done that in the discovery notices based on her review of the case. She's told us in the discovery notices from April, May, June, I'm sure the July one that's coming, she'll say that either a portion of this or some of it was produced previously. We then go back to those documents, we pull those documents, we look at it, we compare it to what they're giving us now, and we make a determination as to whether or not there's anything new. So to a certain extent, I'm happy to sit down with the Commonwealth to talk about those, but I think Attorney Hickman has done the yeoman's work here in terms of identifying information that was not previously provided to the defense. And she's done that in discovery notices that she's already sent to us. So we've already printed out just the information that she said wasn't previously provided to us.
Okay.
For the court's review, for the Commonwealth's review. But another question that I have, Judge, is if we're going to do this sit down, and I'm happy to do whatever is going to make it easier for the court to make this hearing more efficient and more pointed. But here's the concern I have. In some of the Commonwealth's oppositions to what they've filed here, they've relied on email communications. And we don't have all of the emails that went back and forth in this case. So I'm going to make a request now, Judge, for...
Email between who and who?
So their emails, what they're presenting is emails between that. Trooper Proctor was the main detective assigned to this case. He did all the search warrants. He did all the interviews. He did the arrest. He presented evidence before the grand jury. So he had most of it. So to the extent that there are emails out there between Trooper Proctor and any member of the Norfolk County District Attorney's Office relative to this case, not any other case, just this case, I think that we should at least get access to them. We need to understand the communication that was happening between the Commonwealth. I don't even know that when ADA Hickman took over the case, whether there was a sit down with ADA Lally, whether it was, here's my file, this is what's missing from the file, I didn't get to do these three things, could you pick up on that? We don't know any of that, Judge. But I assume that there was communication that went back and forth that I think based on the fact that they introduced the emails, they put them in question. They can't just pick and choose the emails that help them.
Well, I guess I don't understand how they put the emails in question. So I asked about they were emails between who and who, and you're saying they're emails between Proctor and the prosecution team.
That's correct.
Okay, and
I think there's emails that are outstanding, Judge, between different members of the prosecution team, because we have what in essence
different prosecutors taking over. I understand.
Right.
Okay. What do you say?
This is a new request, certainly requesting work product, and not sure how this is relevant to the issues at hand. And I would ask that counsel put that into a motion so I can properly respond. I will say that in my opposition, I did, and I filed a motion to impound these. I did provide in Exhibit 1 all of the, just to simply explain the Milton aspect of this, I provided emails from Assistant District Attorney Lally and the Milton Police to help explain the kind of communication that was going on between them, pre-indictment, after discovery requests, and as the case went forward. The third exhibit to my opposition contains information about the jail calls. Again, that was provided in January from the July 21 grand jury request, subpoena. I provided, I would characterize it as work product, communications between Assistant District Attorney Lally and State Police about the jail calls. And I made representations of that in my opposition, relevant to the issues at hand. This carte blanche, I want every email. I don't know how that's relevant. I don't know how that's going to get us to the issues at hand here.
All right.
Without just simply asking for it,
I understand that that issue is not yet matured for the court's consideration. Let me ask, I beg your pardon?
I'm happy to put it in writing.
Okay. And we'll deal with it after everybody's had a chance to address it. So is there an agreement that everything that was recently produced is new? How am I going to get my arms around what was produced and how it differs from what was previously produced?
I can say that what I have endeavored in my opposition was to provide it, and they're in table forms. What I asked Assistant District Attorney Lally and ADA Hickman as well to get together on this and provide me with which ones were the same, which of the discovery in 2025 was previously produced in some form. And I tried to articulate where there was differences. For an example, like a video that was provided back in 2021 in a converted format was provided in 2025 in a native format. I tried to identify those to give the court kind of a picture. That's not all that was provided in 2025, but that gives you a sense. As far as a deep dive into the substantive, whether the substantive nature of it is new to Mr. King or Ms. Gardner, I don't know that because I don't know what to them they believe is new. ADA Hickman and ADA Lally provided their discovery.
let's get particular. If you look on page 13 of your opposition, you have a chart.
Correct.
Right? You're comparing notice of discovery 28 to previously provided materials.
Correct.
Okay? And you refer to certain materials bait stamped in the notice of discovery 28. It's a little difficult for me to figure out whether this is entirely new based on the chart or whether it's some similar document or similar information, but in a different form or what have you.
Yeah.
But take any line, you know, I mean,
right.
take Bates number 114 towards the bottom of page 13. I guess it's item 114, Bates number 228 to 232. Milton Police Department incident report is the way it's identified.
Right.
And there's an indication here provided to Attorney John Geary.
Correct.
So it looks to me like you're saying that this document, although recently produced by ADA Hickman, was previously produced by ADA Lally.
To the prior counsel.
To prior counsel, and presumably to this counsel also, because I'm sure all the documents were, all the discovery was reproduced when new counsel came in. So I don't know if there's a dispute about whether item 114 in discovery packet 28 is or isn't different.
Correct.
That's what I'm trying to get my arms around.
I understand that, Judge, and we've gone through those, and we've pulled them, and we've pulled out the original that we got in 2021, if there actually was an original, and then we'll put it together with what we got in 2025. So we've done that for a number of items in that chart. I think maybe all of the items in the chart, except for the videos. We haven't compared the videos because we'd be here till next year trying to compare the videos.
Some of the videos are video clips that were produced originally, and they've given you the whole video. And I guess, I don't know if that matters. You know, obviously you now have the whole video. It would have been good if the whole video was produced, but oftentimes there's all 12 seconds in a video that matters. And, you know, it's hard to know whether the omission of the entire video matters.
Understood.
So, you know, if I were to go through the first 6 items here on page 13, for example, of Mr. McKee's memo, how do I figure out whether it is or isn't different? I mean, do you also have a spreadsheet that would sort of match up here and describe what's different or what's not? Are you just doing sort of,
Actual documents.
okay?
We were going to ask witnesses, but now I understand the court doesn't want us to do that. I'm
No,
happy to.
you could, okay, you could, but we'll be here until the cows come home. And I don't know when the last time there were cows in Dedham. But you know, bottom line is there probably is an easy way to figure out or to sit down and coordinate what isn't new and what's not, and then figure out whether it matters.
And to this point about, and you mentioned the word matters.
Well, that's prejudice.
Yeah.
Okay, that's whether there's prejudice.
All of the cases cited by both counsel, myself and Attorney Scapiccio, talk about individual documents that were provided midstream in a trial or right before trial or after trial. There hasn't been an articulation of what of any of these documents prejudices the defendant. And I just can't, I've attempted to provide Your Honor with some kind of macro areas that were new and explain them, but I don't know, I can't respond to what I don't know. I don't know which of the documents that were newly provided prejudice the defendant such that the public doesn't have a view of public trial. And that grave and extreme remedy. Since this motion's been filed, the Commonwealth and the defense jointly requested that the defendant's bail be reduced to $2,500. Judge set it at $10,000. He's posted it. The trial is off the list. What I'm trying to understand, and I asked the court to order it, is if we're going to meet about, I would like to know which of these documents in a pleading prejudices the defendant, so I can respond to it. I have police here to explain some of these macro issues, but I did that almost as anticipatory and trying to help the court, but I don't know even what they're asking or suggesting is prejudicial to the defendant and would prevent him from having a fair trial.
Okay.
So Judge, I think you're right. There are two issues here. There's their failure to produce Rule 14 discovery, which could result in sanctions other than dismissal. And I think that's an easier question because that's all the notices of discovery that ADA Hickman put together, where she noted specifically, this was not provided before, this was provided before. That's easy for the Commonwealth. It's their document. They gave it to me. So they shouldn't be confused by what they gave me and they identified as new. If they're now saying some of the stuff that ADA Hickman said was new isn't new, then they got to tell me about that, because that's what they had represented and that's what ADA Hickman had represented when she took over. So to the extent that we all need to sit down, I'm happy to do that, Judge, but there's two different lines of questioning here. One is, where's the stuff been since 2021? Because my client was in custody for almost 4 years, awaiting trial. We had a September trial date. And then where's the prejudice? So they're jumping all the way to the prejudice, and we still don't have our arms around where's it been since 2021.
Right. So before I deal with the prejudice issue, it seems to me that I ought to know what is new and what you think is materially new. Okay? And I know that puts a burden on everybody to work together, but it seems to me that we ought to do that. I have two other matters on this morning, so we're gonna break by 11:30 today, okay? I think I can begin by taking evidence on the question of where has this stuff been and why wasn't it turned over earlier? And we're gonna have to adjourn. We're not gonna finish this today. And in the interim, I can have you folks get together and do a comparison to figure out this is new because it has somebody's handwritten notation in the upper right-hand corner. This is new because it's the full unredacted video and the redacted video of 12 seconds is the only relevant portion, or whatever, okay? And we can get our arms around materiality, we can get our arms around prejudice, and maybe it will also focus some of the attention on why wasn't this turned over. Because it may be that this is all stuff that was annotations in one person's file. I don't know, you know. I'm not saying that's the situation, but it'll focus us a little bit. But it seems to me we can use the morning well by beginning on the first question, which is why wasn't this turned over in a timely manner? How do you want to proceed on that score?
I would then call ADA Lally first because he was the first one to touch the file, Judge.
It's the defendant's burden. Certainly it's our motion, counsel's motion. I do also have here, just for I have 2 Milton police officers and state police, Lieutenant Tully, that I would offer the court to explain the Milton aspect and the items that ADA Hickman produced after going to the Milton Police Department and copying paper files and receiving an electronic file from them.
Okay.
That would take care of a bulk of what ADA Hickman provided in the spring of this year.
Why don't we start with ADA Lally?
Sure.
Okay. And it may be that you also want the talk to the Milton people.
Well, I'd ask that everybody, all the witnesses be sequestered, Judge.
That makes sense.
That's fine.
Okay.
And they've been here all morning.
And
May I approach on behalf of ADA Lally?
sure.
Briefly. Judge Attorney Pat Hanley on behalf of ADA Lally, who's...
Oh, you're near a microphone. You're good. Okay. Go ahead.
Okay.
Give me your name.
Patrick Hanley on behalf of ADA Lally.
Okay.
I had filed, I think, either Thursday or Friday, and served upon the Commonwealth and Attorney Scapiccio a motion to limit or perhaps modify the format of any presentation by ADA Lally. ADA Lally is an officer of the court. ADA Lally, I anticipate, is in a position to answer many of the questions that you have or that are raised by defense counsel, but that he should do so from counsel table and address them directly rather than in response to questions. I suggest that it will be faster. He's prepared to do it, and if there's follow-up questions that the court has or that are derivative from defense counsel's motion, I suspect that he'll be in a position to answer them. And so I'd suggest that be the format.
Why?
And because it will be faster. It also obviates the need to examine defense counsel to the extent there's any question of what was sent to defense counsel before or what was raised in documents before. Defense counsel, I would suggest, shouldn't be on the witness stand, and he shouldn't be on the witness stand. The last thing I would say is, if the court is inclined to put him on the witness stand, I'd ask for the opportunity to, at the conclusion of defense and Commonwealth's questioning, to question him and raise anything that has not been raised in his testimony by that point.
The motion is denied. Mr. Lally can testify like any other witness. He has relevant testimony.
Thank you.
Okay.
And the other part of this is, thank you.
Okay.
And the other part of this is, these were, and I'll just pass them up to Your Honor. These were the subpoenas that both ADA Hickman and ADA Lally received from counsel, seeking production. It probably dovetails with counsel's request for all the emails. I would ask that the court quash in so much as the request for the file and any work product and anything that goes beyond Rule 14, mandatory discovery, anything that involves work product, mental impressions, or anything of the such should not be part of this questioning.
So right now, part of this questioning is, what did this ADA know?
Right.
What did he do?
Thank you.
Okay, who did he talk to? That's arguably work product. It gets discovered in this context because the question is, why wasn't this stuff produced in 2021? I understand that could be embarrassing for the office. I understand that could be embarrassing for certain individuals. That's where we are right now in this particular case because lots of stuff from 2021 wasn't turned over, okay? So it may be that emails become relevant to this testimony, okay? Who knew what when, and what did they do or didn't do in order to follow up? So I'm going to have to deal with this on a question-by-question basis. I cannot quash it across the board, all right?
And I would agree, Your Honor. I actually, to that point, I have included emails to explain the issues at hand. So this is not, when I can understand an issue, I provided the emails to help explain it.
Okay, all right.
Thank you.
ADA Lally, Your Honor?
Yes. Mr. Lally, if you could come forward to be sworn.
I apologize. We have witnesses here. You want
Yes,
them?
sequestered, yes.
So council's also, we have a motion to quash this subpoena entirely. ADA Hickman, do we want ADA Hickman present for this questioning?
I do not judge it. She's going to be a witness as to what how the condition of the file is she found it. I don't think she should listen to what Lally says he had in the file before she testifies. That's no dispersion on ADA Hickman at all, Judge.
I understand. I'm going to overrule the request for sequestration of ADA Hickman. She's counsel of record now and an officer of the court, and I'm confident that we do not need to extend the sequestration order to her. Your objection's preserved. Attorney Costa, to the extent you join in the objection.
I'm joining the objection, Your Honor.
And you have a standing joining of objections, if you wish, all defense counsel.
Thank you.
Okay, but others should be sequestered.
The witnesses are sequestered. Thank you. You solemnly swear to give the court in the case down here and true the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Thank you.
Good morning, Mr. Lally. In a loud, clear voice, could you please state your name, spelling your first and last name for the record?
Sure. Adam Lally, A-D-A-M, last name L-A-L-L-Y.
And what do you do for a living, Mr. Lally?
Assistant District Attorney with the Norfolk County District Attorney's Office
And how long have you worked for the Norfolk County District Attorney's Office?
since 2005.
20 years?
Yes, almost.
What did you do before you worked for the Norfolk County District Attorney's Office?
Started with the District Attorney's Office straight out of law school. Worked a couple warehouse jobs, things like that during.
Sorry,
I worked a few warehouse jobs, things like that during law school. Went to school at night.
Okay. And what school did you go to?
Suffolk.
Suffolk Law?
Yes.
And undergrad?
Undergrad, I went to the University of Southern California.
Okay. And what was your well, at some point, how long were you in the office before you got assigned to the homicide squad? Oh, homicide unit, I'm sorry.
I'm not sure that it's an assignment to the homicide unit. I would say the first homicide that I had outside of the realm of motor vehicle homicide was probably 2015, somewhere in there.
Okay. And let me back up a little. What type of training did the Norfolk County District Attorney's Office offer you in order for you to be able to comply with Rule 14 discovery?
Objection.
Sustained.
So when you started at the Norfolk County District Attorney's Office, you sat in district court?
Yes.
Okay. And how many district court cases would you say you tried?
I have no idea. A lot.
More than 100?
Probably.
Okay. And in all of those cases, were you able to comply with Rule 14 discovery and turn over the discovery that was required under Rule 14?
Objection.
Sustained.
Let me ask you this. The hundreds of cases that you tried in district court, was there ever any allegation that you didn't turn over information?
Objection.
Overruled.
No.
Okay. And then at some point you moved to Superior Court. When was that?
Began working on Superior Court cases probably in 2006, full-time assigned to Superior Court in 2012.
Okay. When you say full-time assigned to Superior Court, what does that mean?
So what that means is during the interim period from 2006 to 2012, I had cases in Superior Court, but I was primarily assigned to the District Court.
So you were trying cases in the Superior Court, but you were still trying cases in the District Court?
Correct. Actually, I still do that to this day.
You still try cases in the District Court as well?
I do.
Okay. But you said at sometime in 2012, you were assigned to the Superior Court. Does that mean you came here every day?
Correct.
Okay. And what type of cases were you assigned in 2012 when you became a Superior Court DA?
Variety, pretty much ran the whole gamut. Narcotics cases, sexual assault cases, child abuse cases, breaking and entering, armed robbery, whatever I was assigned, that's what I did.
How long after you got to the DA's office did you start trying what they call life felonies?
I don't understand the line of inquiry. Everybody who is in the DA's office is responsible for complying with Rule 14 and is expected to know the confines of Rule 14 and to comply with it. So the backstory here is not particularly useful. What I want to know is what ADA Lally did in this instance.
Understood, Judge. In any event, when were you assigned to the Miles King case? And Brianna Gardner, I'm sorry.
Probably within a day or two.
A day or two of what?
Of the shooting and the murder occurring.
Okay. And how do you get assigned in the district attorney's office? Do they email you? Do they call you? How do they do that?
Objection.
Overruled.
I received a call from the first assistant.
And who would that have been at the time?
At the time, that would have been ADA Lynn Beelan.
Okay. And did she tell you you were assigned to this homicide case?
Yes.
But what does that mean to you, being assigned to a homicide case? What does that mean?
Well, I mean, at that point, it was an investigation. So as far as assisting with the investigation, should charges arise, handling the prosecution from there out.
Okay. So once you get assigned to the Miles King, Brianna Gardner case, is there a policy within the Assistant District Attorney's Office in Norfolk County on how to gather information that's required under Rule 14?
Objection.
Overruled.
A specific policy, not that I'm aware of, no.
Okay, so there's no policy that you're aware of in the DA's office that that details how to gather information. Is that what you're saying?
Not that specific to that, no, not that I know of.
So how do you gather information? How did you gather information in the King Gardner case that was required under Rule 14? What did you do?
Objection. Just specify what is, it's too vague.
Overruled. Question is, what did you do?
So what I do...
And I think we can take it in chronological order. We'll start at the beginning and then we'll have follow-up questions.
Sure. So what I do is what I do in every case, depending on how many different departments are involved. In this case, there was a local department and state police involvement. So I would make appropriate requests for any and all information that they had, any information that, you know, specifically I could outline or delineate as far as what I felt was relevant. And
Stop right there. How would you make those requests?
Typically what I would do is write out a formal discovery request, submit the form to any involved departments, and communicate either via phone or email to whoever the relevant party was that I was requesting discovery from.
When you say discovery forms, what do you put on? What did you put on the form in this case for Gardner and King?
Initially, it would be for any and all police reports, any and all photographs, any and all information as to who was present, lab reports, if they had access to fire department, run reports, any lab personnel that responded to the scene, you know, so that I would have an idea as to whether or not there was testing that was going to be conducted or items have been recovered from the scene, copies of any and all search warrants, including applications, affidavits, copy of the warrants, any returns.
And let me stop you there. Do you have a memory in this case of asking for all the information that you just told us you normally ask? Did you do that in the Brianna Gardner and Miles King case? Did you ask for all of that information?
Yes, and just for clarity purposes, when I'm initially doing this, it's not the Miles King and Brianna Gardner case.
It's just an investigation?
Correct.
Okay.
Well, and more to that point, Ms. Gardner didn't become a focus of the investigation until later on.
Okay. So while you were investigating without a defendant being a suspect, at least not initially, you asked which departments for this information?
The State Police, Norfolk County Detective Unit, as well as the Milton Police.
I can't hear you. What was the last one?
Milton Police.
Milton Police. Okay, so you asked Milton Police, you asked the State Police. Who in Milton Police did you ask, and who in the State Police did you ask to send information?
The Milton Police would have been, at that time, Lieutenant Michael Collins. The State Police would have been Trooper Michael Proctor, as he was a case officer, and Lieutenant Brian Tully.
And so you have emails going to all three of them asking for all of the information that you just listed, which would be normal information that you'd ask in any case after a homicide. Is that right?
Yes.
And let's just take Mr. Proctor, Trooper Proctor, did he respond to you?
Yes.
And what did he provide you?
At varying
No, to the extent he recalls, he can testify.
So at varying times, there were different productions of material, whether it was what was available at that time. So initially it would have been just whatever reports were available at that time. Later on would have been photographs, video.
So how often would you say you emailed or communicated with the state police, and specifically Trooper Proctor or Trooper Tully, regarding discovery in this case?
I cannot tell you how many times via email, but I mean, it was a constant conversation, particularly throughout the grand jury process as far as discovery was concerned.
Okay, so when you say a constant process, was there a time period where you asked for stuff and you didn't get it, so you were re-asking for it, or is it always new information that you're getting from the state police?
I think it would vary. I think there were certainly items that I probably had to ask for more than once, but there were definitely items that I had asked for and was provided promptly, and then moved on from there to either additional information or that avenue was complete. So
do you keep records of, I asked for search warrants, I asked for crime lab stuff, I asked for witness statements? Do you keep records when you receive that information to be able to check off to say, I got these things, they're no longer outstanding and the rest of this is?
I mean, I keep records in the sense of a list of items I'm looking for, and obviously when I receive something, then yeah, that would get checked off the list as far as I'm not looking for that anymore because I have it.
Okay. So if you got a set of grand jury minutes from a witness that you know testified in front of the grand jury, you'd check that off your list?
Well, as far as yes, I mean, I was at the grand jury, so I know who testified at the grand jury, but as far as receiving the minutes, yes, I'm aware of the dates, and when I receive the minutes, then that would check that off the list.
I missed, I think, a question and answer. One question earlier. I think the question was, do you keep records of what you requested? What was your answer to that question?
So records as far as what was requested, I would always have at least in some form, some sort of running list of items I was looking for, and then if I received an item, then that would be something that would be off the list. Now that list would be obviously added to as information develops, and there might be additional items that I'm looking for.
And presumably because it's on the list, you've made the request?
Yes.
Okay.
And so you'd have, whatever's on the list, you'd have emails requesting that information, is that right?
Yes.
Okay. And then if they emailed back, you'd have checks off of your list that you got whatever it was, that, you know, maybe you were asking for 10 things and you got 5. You'd check those 5 things off your list, is that right?
Yes.
Is there any other mechanism you used to document what you got from, just right now we're talking about the state police, Trooper Tully and Trooper Proctor?
I'm sorry, any other mechanism of doing what again?
Keeping track of what they're producing for you. Is it all just emails and check marks on a list? Or is there some other way that you keep track as well?
No, I mean, it would be something that I would have a list of items that are outstanding that would be, you know, followed up on if they hadn't been received at that point, and then I would follow up with whoever the appropriate person was to get copies of those.
And these lists remain in the file? Your lists with the check marks remain in the file?
To the best of my knowledge, yes.
Okay. And have you reviewed any of them before you testified here today?
No.
Okay. Is there a reason you didn't review the file before you testified here today?
I don't have the file.
You work for the DA's office, right?
I do.
And it's in the DA's office, right?
Yes.
And you knew you were going to be asked questions about this case, right?
Yes.
And you didn't do anything to educate yourself about what you did initially on the case?
Objection. This is her witness.
Well, I'm not sure I agree with that as an objection, but I'm going to sustain the objection as to the relevance. He did not review the file. Next question.
So what did you review in preparation for your testimony here today?
I reviewed portions of the file. I reviewed some of the items that have been produced by ADA Hickman. I reviewed search warrants. I reviewed police reports. I reviewed, you were asking specifically as far as checklists or notations. I didn't review those, but I did review, I have portions of the file. I have access to the file, and I did review portions of the file. Okay.
So you did review portions of the file?
Yes. Oh, yes.
You just didn't review your checklist?
No.
Okay. Now, in terms of the Milton Police Department, do you also have emails going back and forth to the Milton Police Department asking for certain documents?
Yes.
And who in the police, would that be Lieutenant Collins?
Yes.
Anyone else in the Milton Police Department were you looking for documents from?
On this case, I don't believe so, no.
And did you keep the same type of list that you kept for the state police of outstanding things that you were looking for the Milton Police Department?
Yes.
And what did you get back from the Milton Police Department? Do you remember?
Items of similar nature that they had access to, as far as police reports, photographs. I don't believe Milton did any of the search warrants in this case, but other items of discovery, video that they recovered, that there's a litany of different items.
A litany of different items? Did you
Yes.
say? Okay. And those would all be memorialized by email? Is that how you did it?
Yes, that's, I think, what Mr. McGee attached as Exhibit 1. It's about 137 pages.
Of emails back and forth between the Milton Police Department and you?
Correct.
And so at what point do you know that you have all of, so other than, strike that, Milton Police, State Police, any other person or entity that you sought information for in this case?
Certainly.
I'm sorry?
Yes.
Who's that?
Be the Office of the Chief Medical Examiner, be the State Police Crime Lab. There were some items that were outsourced to Bodie Technology Lab in Lorton, Virginia, where they did some additional forensic testing pursuant to DNA. They have different methods that our lab does not. Milton Fire Department, I believe Fallon paramedics were involved in the transport of the victim, Mr. Simmons. That's all I can think of at this point.
Okay. And would you communicate with those agencies the same way you communicated with the State Police and the Milton Police via email?
For the most part, could have been a phone call on some of those
All right, so let's stop
issues.
there. If there was a phone call, how did you memorialize what you requested and what they said in a phone call?
Notes?
You have individual notes.
Yes,
And where would those notes be right now?
in the file.
Okay. So do you keep like a running page of all of the notes that you've taken in the case with communications that you had with all of the other entities and officers in State Police in this case?
Not all in one location, but it would be sort of divided up by different entities as far as what I was requesting from that specific entity and what I was looking for, what I was still waiting for, what was still outstanding, things of that nature.
Okay. So what happens when you ask for something, let's just say from the State Police, and they don't give it to you? What's the next thing you do?
The next thing I do would be to ask for it again.
Okay. How many times do you ask for it before you have a meeting with the State Police to look at their file?
Objection. The biggest objection I have here is that we're not speaking about any individual document, any individual date, vague questions about
Yeah, this is general practice,
General practice.
generally Mr. Lally's practice. I think part of the issue here is we don't have very specific items that are being referred to.
Right.
But I think I'm going to overrule the objection and give Attorney Scapicchio a little bit of leeway here in terms of general practice.
So in general, how many times do you email for the same document before you go to the State Police and start to have a sit down with them?
I think it varies. I think it would be depending on a lot of different factors as far as what the item is, what the explanation is for why I don't have it yet, whether it's not available or whether it's something that they're currently working on, or if it's something that I know has been completed, and I've asked for it multiple times and I still don't have it. I'm not saying that even happened in this case, but if in a general practice, if that were something that were going on, then yes, I would want to sit down with somebody and figure out exactly what's going on.
Okay. So let me ask specific questions about this case. When you reached out, let's start with Trooper Proctor, in this case looking for information, and there were emails back and forth. Were there any occasions where you did not get the documents or the information that you were seeking from Trooper Proctor?
I don't recall anything specific other than if it was a situation where I'm looking for a report about something and that report hasn't been completed yet, or that item hasn't been obtained yet for whatever reason. But I don't recall in this case ever asking for something and just not getting it.
Do you remember asking Trooper Proctor for the search warrants that he did in this case?
Yes,
And the affidavits accompanying the search warrants?
yes.
And did he provide them to you?
What I received was a partial affidavit for search warrant,
Stop there. Did he provide them to you, yes or no?
some,
How many search warrants do you recall there being in the King Gardner case?
in 2021 or beyond.
Let's start with 2021. How many search warrants? You guys pulled the search warrants?
6.
6 search warrants. Did he, when you asked, and he signed all 6 search warrants, is that fair to say?
That's my understanding, yes.
Okay. And so when did you ask Trooper Proctor for the search warrants?
In July or August of 2021 when they were filed for.
Okay. And when did you get all 6 search warrants from Trooper Proctor?
I didn't get all 6 search warrants from Trooper Proctor.
You did not?
I did not.
Okay. So did you get 1 search warrant from him?
From him specifically, I received a portion of the affidavit for search warrant 306 and the entire affidavit for search warrant 348.
Okay. So you got portions of 2 search warrants, and you knew there were 6 search warrants. Is that right?
Yes,
Did you make notes somewhere in your file? Geez, I asked Trooper Proctor for these 6 search warrants. He hasn't given them to me yet?
I believe, yes.
Okay, those notes are in your file.
I believe so, yes.
Okay. And then when you didn't get the search warrants from Trooper Proctor, did you meet with him?
Yes, I mean, specific to that, I don't recall any specific meeting related to search warrants, but we did meet several times in relation to this investigation in this case.
But you understand that search warrants are Rule 14 automatic discovery, right? And you knew there were 6 search warrants, right?
I did.
And so when do you realize that you don't have all 6 search warrants? How long into the process? Do you know right away you don't have them all? Or do you not know for a long time you don't have them all?
I don't think I realized at that time that I didn't have them all.
So how, and I guess I'm confused about how your system works. You said you had a system where if you asked for something and you didn't get it, you would then follow up with the police officer asking again and again. Did you do that with Trooper Proctor in this case with the 6 search warrants?
Yes, I believe so.
How many times did you email Trooper Proctor asking for the 6 search warrants?
I don't know.
More than 10?
I don't believe so, no.
Okay. How far in between each email? Did you wait a month and email him again? Did you wait a week? Did you wait a day? How long in between your requests to Trooper Proctor to produce the 6 search warrants in this case?
I don't know.
You don't?
No.
Did you review your emails before you came here today?
Some of them, yes.
Did you see any emails to and from Trooper Proctor regarding the search warrants?
Yes.
How many did you see?
I don't recall.
More than 5?
Yes.
More than 10?
I don't know.
What are the dates of the first time you asked Trooper Proctor for the search warrant?
Specific date, I don't know.
How long before the next time you asked him for a 6 search warrant?
Specifically, I don't know.
Was it months or weeks?
Weeks.
Weeks later. Okay,
Yes.
so that's 2 times you asked him. What about the third time? How much time went by?
I don't know.
Months or weeks?
I don't know.
What about the 4th time?
Again, I don't know how many times and I don't know specific dates.
So I guess my question is, how does your system work if you're not getting the discovery that you're asking a police officer for, and you're asked for it, let's just say 5 times? What do? Do you go to the office and you sit down and say, give me these search warrants, I have to turn them over?
Yes.
You did?
Yes.
Did you do that in this case?
Yes.
You go to Trooper Proctor and say, give me the search warrants because I have to turn them over.
Yes.
When did you do that?
Sometime prior to the defendant's arraignment in December of 21.
November of 21, did you say?
December of 21.
December of 21. So when you get to his office, do you go there or do you tell him to come to your office? I don't know how that works.
Either way, I don't
Remember how you met about the search warrants the first time? In other words, did he come to you or you go to him?
I don't know.
Okay. So you have a sit down.
Yes.
and you ask him for the 6 search warrants, and what does he say?
That you will get them to me.
He will get them to you.
Yes.
Okay. If you tell him I have an obligation to turn this over because it's Rule 14 discovery, I need it right away, I've asked for it 5 times, what's the deal?
Those specific words, no, but the gist, yes.
Well, tell me what you said specifically.
I don't know.
Well, give me a best estimate of what you said to Trooper Proctor after you asked 5 times
Objection.
search warrants that he didn't turn over.
Sustained.
So, did you keep any notes of your conversations with Trooper Proctor when you were asking for these 6 search warrants that he didn't give you?
No.
Why not?
It was something that I knew that was outstanding. It was something that I had asked for in written form numerous times. I didn't feel the need to write a note that I asked for it again.
So that's the first sit down. Did you send emails after the first sit down saying, hey, you promised me you're going to send these 6 search warrants, I still don't have them?
Objection, assuming facts.
Overruled.
I'm sorry, could you repeat the
Did
question?
you send another email to Trooper Proctor after you had this sit down sometime in December of 2021 saying, hey, you still didn't send those 6 search warrants, can you send them over?
Yes.
How far after Mr. King's arraignment in December of 2021 did you send that email to Trooper Proctor?
I don't know.
Was it a year?
I don't think so, no.
What do you think? What's your best estimate of when you sent that email after you sat down with Trooper Proctor?
I would say probably a few months later.
All right, a few months.
Yes.
So February, March of 2022, is that what you're thinking?
I don't recall specifically.
So when you're in this room with Trooper Proctor asking about the 6 search warrants, do you ask him for his file? Like, give me your whole file so I can go through it and figure out what's in it?
No.
Why not? You're there. There's outstanding discovery. You have the obligation, not the police officer. Why don't you ask?
I entrusted that whatever discovery I was requesting, I would get at some point in a timely fashion and then turn it over.
But you didn't get it. You asked for it 5 times. You didn't get it. You had to go see him. You have them right there now, and you still don't say, give me your file? Let me go through it?
No, I did not.
And when he says you'll get the search warrants, I'll send them to you. Did he have them? Did he have copies of the search warrants? He just wasn't giving them to you?
That I don't know. You'd have to ask him.
Well, you don't get the search warrants in any event after that sit down, and you send another email. What's Trooper Proctor's response to that email?
Again, I don't know that I sent another email, but I know that there were subsequent conversations about it. Whether it was what format it was in, I don't know.
Okay, and at this point, you have to be getting a little upset with Trooper Proctor that you're asking for information that he's not giving you, right?
Objection.
Overruled.
I'm sorry, your question again?
You have to be getting a little upset at Trooper Proctor that you're asking him for information that he's not giving you, right?
I would say upset, frustrated probably.
I'm sorry?
Frustrated probably.
Oh. Judge, can we approach sidebar just briefly? I know.
Sure.
Wow. Sidebar. We are at sidebar, ladies and gentlemen. Sidebar. My name is Grant Smith Ellis. It's a sidebar. It's bad. We're back. Somebody put the sheep in the chat. We have a sidebar, and Lally just admitted that he was frustrated with Michael Proctor for hiding text messages in unrelated cases. My name is Grant Smith Ellis. We are watching, ladies and gentlemen, we are watching coverage from Norfolk Superior Court of an evidentiary hearing related to 4 criminal cases investigated by Michael Proctor, Brian Tully, and other members of the state police unit, and their potential discovery violations in those cases. Proctor did not show up, but Lally is there. Brian Tully might testify. Tully, of course, was one of the people who was alleged to have been involved with the leaking of an unredacted extraction of Lindsay Gattani's cell phone, including pictures of her giving birth in the Aidan Kearney case. So that whole unit, it's turning out they were just really engaging in a lot of discovery violations. It's the Massachusetts State Police Unit who was detailed to the Norfolk DA, the unit that's like been torn apart, and the ones who also potentially were involved in the cover-up of Sandra Birchmore's murder. So listen, folks, this is a big deal. I don't know how this came out of absolutely nowhere and just started happening, but we are at sidebar. Adam Lally is on the stand, the ADA from the Karen Reed and John O'Keefe case, getting questioned by a criminal defendant for a lawyer for 2 criminal defendants who were investigated by Michal Proctor. All right, so this is absolutely incredible. I don't know how this happened. It has very serious consequences. This was not the only discovery violations, in my opinion, that we're going to hear about related to this office. It's not really that Lally did anything wrong. It's more like that unit, the MSP unit, was all up in sort of chaos. And this is what this is the really big fallout. There's a lot of fallout in terms of this case, in terms of this unit kind of getting like exposed. None of it really to do with Karen and John O'Keefe, but a lot of it to do with what this unit was up to. And I don't know exactly what's going to come out, but it's a big deal. And we're watching it. It's not just the private text of Proctor. It also has to do with the way that Proctor, in other cases, unrelated to Karen Reed and John O'Keefe, was with, like, not really giving evidence over to the DA, so the DA couldn't give it to criminal defendants. And again, these are 4 cases investigated by Proctor, Tully, and others that are rife with discovery violations, according to this lawyer. That's why Adam Lally is on the stand, and Adam Lally's getting asked, were you frustrated with Michal Proctor for withholding this information? And he was like, yeah. Okay, so this unit, I'm telling you, and Brian Tully and Proctor and whatever were involved in the unit. How have you ever heard of a state police officer handing over a 15-year unredacted extraction of a victim's phone to their lawyer directly with pictures of them giving birth, unredacted? No. And the only stuff removed from that phone extraction was for messages from Tully to Lindsay and from Kate Peter to Lindsay. Come on. This unit, that's what was really going on. It's not necessarily that the Karen Reed and John O'Keefe case was investigated poorly. It's that they were doing a lot of other weird stuff, and now all these other lawyers caught on to it, and now you got Adam Lally on the stand being like, yeah, I was frustrated with Michal Proctor. All right, because Michal Proctor and that unit were doing weird things. And the Sandra Birchmore murder cover-up is only one small component of a much larger web, because the Lindsay Gattani phone extraction is part of it. Like, this unit, I don't know why this happened. They got entrenched in that area. They were there longer than the DAs, and it led to this spider web. People have to stop seeing it as they just because they investigated Karen Reed, they were good people. Oh, it's so frustrating to me. All right, we're back.
In any event, ADA Lally, a couple of months goes by, you still don't have the 6 search warrants. What do you do?
I don't know. I mean, I'm specific to the 6 search warrants. I don't recall as far as there was a topic that was discussed repeatedly. Obviously, I never received them because I never provided them to you or to Ms. Costa.
Okay. So I guess what I'm saying is you knew they existed, and you knew that, let me just say this, you knew that all six search warrants existed. Is that right? Yes,
we went through all six of the search warrants on the last day of the grand jury presentation on November 19th, 2021. That's in the grand jury minutes as far as going through each of the materials, each of the search warrants, that there were search warrants, how that material was obtained, and the material that was returned in response to 3 of the search warrants was marked as grand jury exhibits 33, 34, and 35.
Right, but not the search warrant.
Correct. Well, no, actually, I'm sorry.
Information in front of the grand jury about 6 search warrants that you hadn't seen, and you put returns or information that had been returned in front of the grand jury on search warrants you had never seen.
So with
Answer that question.
And I'm trying to. So
okay.
With regard to those 3 search warrants, that was 306, 307, and 329, which were the call detail records for your client, the victim, Mr. Simmons, and Mr. Jeanette. The materials that came back from the cell phone providers also contained a copy of the warrant, as well as the addendum to the warrant, which was then also provided to you and Ms. Costa in discovery.
But not the warrants themselves.
No, the warrants themselves and the addendums, not the application and not the affidavit.
Right. So you understand that in order to make a determination as to whether or not you're going to suppress certain information, you actually need what you asked for and what you, in the affidavit that told the clerk magistrate why you had probable cause, right?
Objection.
I can take judicial notice of that, and I'm sure Mr. Lally knows that.
Okay, so you get in front of the grand jury. When do you present this case to the grand jury?
Began in July of 2021. That grand jury sat in July, August, and September. The presentation had not been completed at that point, so there was a motion to extend the grand jury. And I believe there was one subsequent date that we went before them on November 19th, 2021.
November what?
19th, 2021, that's when indictments were returned.
In 2021?
Correct.
Okay. So at some point when Mr. King is arraigned, you understand at that point, Rule 14 kicks in, right?
Yes, I mean, I'm thinking,
right?
I'm thinking about Rule 14 well before that.
Okay. And you know, when you arraign Mr. King, you still don't have the search warrant. Do you have another conversation with Trooper Proctor about, hey, where are these search warrants? I have to turn them over?
I'm sure I did.
And do you know when that would have been?
I don't.
Okay. And then, remember at some point in December of 2021, receiving a discovery notice from me. Hey, Prosecutor Toronto.
Yes.
This is just my discovery notice.
That a discovery motion, or what is
Motion,
that?
I'm sorry, motion, Judge.
Yes.
Okay. And do you remember, after having filed this motion, you asked the time to go through and make sure that you can comply with all the requests, right?
Yes.
And you didn't have any specific objections to anything that I was asking for, right?
At that time, no.
Okay. May I Prosecutor Toronto?
Yes.
Sorry, Judge.
Is that an exhibit? Is that a docket entry?
It is a docket entry, Judge.
Do you know what it is?
I think it
Or we can mark that just so that there's a record of what you're showing the witness?
has my writing on it, Judge. So
All right,
I won't
so-
mark it. But I'll do it after the hearing. I'll find the exhibit and I'll make a clean copy and send it to the court, Judge. So once you get the discovery notice, you know for sure that there are certain categories of information that we're looking for, right?
Yes.
And number one is all automatic mandatory discovery under Rule 14, right?
Correct.
Would you consider those search warrants automatic mandatory discovery under Rule 14? Okay. And we were looking for any and all statements of witnesses, is that right?
Yes.
And we were looking for all exculpatory information, whether
The
tangible.
document speaks for itself.
Okay, that's fine, Judge. So after I filed this motion to December of 2021, you have another conversation with Trooper Proctor saying, give me the 6 search warrants.
I'm sure I did. My general practice is if there's any discovery motion that's filed by counsel, what I'll do is I'll send that to the appropriate police personnel as far as making requests and making sure that they're apprised of what's been at least asked for.
Excuse me, and did you do that in this case? Did you send my motion for discovery to Trooper Proctor, to the Milton Police, to the crime lab, to the medical examiner's office? Did you send it to all of those entities?
Every motion that you filed, yes.
Okay. And then what do you do to follow up with each of those entities? Let's start with the state police. They get a copy of my discovery motion. You're looking for all of the evidence that they have, and specifically these 6 search warrants that, for whatever reason, Trooper Proctor hasn't given you. When you follow up, how long does it take you to follow up from the time that you give them the motion until you get an answer from them?
Specifically, I don't know. Typically, I would give it a couple of weeks or so.
And after a couple, and in this case, did you give it a couple of weeks, you think?
Probably.
Okay. And then what happens?
And then I'll follow up again.
When you say follow up, do you send another email, or do you get in your car and drive down there and say, we got to end this, give me this stuff?
I email or a phone call.
Okay. And so did you email or phone call, or make a phone call to Trooper Proctor in this case?
I'm sure I did.
And what was his response?
I don't
When you
recall.
asked for the 6 search warrants?
I don't recall.
Well, do you have any notes of your conversation with him? Maybe you're taking notes?
I don't believe so, no.
Is there a reason that you didn't take notes when you spoke to Trooper Proctor after these search warrants had become an issue? That you wouldn't take notes of what Trooper Proctor told you about the search warrants?
So you're asking me about a conversation that I don't recall specifically when it happened or exactly what was said. So whether or not I took notes for that conversation, I don't know. What I would do typically in my general practice is to follow up with whoever I had outstanding discovery requests in relation to try to get whatever information that I was seeking.
Okay, and so did you follow up with Trooper Proctor about the six search warrants?
I'm sure I did, amongst probably a number of other items.
Okay, and then you knew the case was going in for another date on discovery, right?
Yes.
And you knew you'd have to answer to the court what you've provided and what's outstanding. Isn't that typically how it goes on discovery dates?
Yes.
Did you ever tell the court, geez, I have these 6 search warrants that Trooper Proctor has, I can't get my hands on them, can you issue an order, or can you help me out here?
Did I do that? No.
So, when you went to court, do you remember representing to the court that discovery was ongoing and that you were producing as much information as you could? Remember that?
Typically, that's what I would say if that was the case, yes.
Okay, but you knew when you represented that to the court that you didn't have the search warrants, right?
Yes.
So what was your plan? How are you going to get them?
As I stated, what my practice would be if there was some outstanding item of discovery, I would request it and follow up if I hadn't received it.
But you did that. You requested it 5 times. You went to see him. Then you got my discovery motion. You sent that to him. You waited another month. And then what happened?
I don't recall.
Well, don't you tell him, get me these things now, I'm coming down your office?
Objection.
Overruled.
Did I ever tell him that? No.
Okay. So what do you do when he's not complying with your request? Let me ask you this. What's the policy in the office of the District Attorney's Office in Norfolk County when a state trooper is not complying with a request for discovery?
Objection.
Overruled, if there is a policy.
What's the policy?
I don't know any specific policy related to that.
Okay. So do you go to your supervisor then and say, hey, I've asked Trooper Proctor 5, 6, 7 times for these search warrants. I've been down to see him in person at least once. He's not giving them to me. What do I do?
No.
Did you ever have another case other than Mr. King and Ms. Gardner's case where a state trooper didn't give you search warrants that you had been asking for since before indictment?
Objection.
Overruled.
Not that I recall, no.
Okay.
Your Honor, may I be heard on one slight issue? The discovery, the discovery request the counsel is speaking to, I don't believe that it was ever docketed. I don't have a copy of it. I've never seen it. So
The motion, the motion?
The motion for discovery was filed. He got
it may not have reached the docket, as I guess.
I want to make sure that you see it, though. Let's make sure
I'm speaking about it a lot here, and
No.
I've never seen it.
Attorney Scapiccio, can you just give it to Mr. McGee for a second?
Sure. You think it would be in the file?
I would think it would be in a file. Is that a clean copy?
That is a clean copy, Judge.
Can we mark that? Should we mark it?
It's unsigned, and it's probably, I don't know if it's a draft or a,
Oh, the non-signed, all right, so let me get you a signed copy, Judge.
I don't know what was.
The bottom line is, this witness said he received it, Judge. I know I wouldn't have not filed it. We talked about it in the hearing. And I think there is a transcript, Judge, of a hearing where we talked about the discovery motion, and the court had it.
All right, we'll figure that out.
Can you guys put the transcript?
We do have ADA Hickman did have a copy.
You do have a copy?
I never saw it on the docket. I was working right off the docket.
Okay.
So,
And just so the record is clear, we have marked it? You want it marked as Exhibit 1 in this hearing?
yes, Judge.
Sure.
All right.
Get you a signed copy, apparently.
All right, that will be Exhibit 1.
Thank you. I'd also, at some point, Judge, like to mark the pretrial conference report, in this case.
Thank you.
So this had never happened to you before, Attorney Lally, and you didn't go to Lynn Phelan, who was your supervisor, and ask her what to do. What was your plan? How were you going to solve it?
I don't recall specifically having a plan. If there were a situation where I was asking a trooper or a case officer for something and I had not yet received it, I might get that person's supervisor involved as far as saying, I've asked for this a few times, I don't have it.
Okay, so let's stop there. Trooper Tully was Trooper Proctor's supervisor, is that right?
Yes.
Did you go to Trooper Tully and say, hey, I don't know what the deal is, but I can't get these 6 search warrants from Trooper Proctor. Can you have him send them to me?
Specifically about the search warrants, I don't recall.
You didn't go to a supervisor.
I don't know if I did or I didn't.
But as you sit here today, you don't remember going to a supervisor, is that right?
I know that there were a number of meetings in relation to discovery that Lieutenant Tully was present for, along with Trooper Proctor, but going specifically to his office to demand 6 search warrants, I don't recall that.
Okay. So how much time goes by before you ask for the search warrants again?
I don't know.
Is it a year?
I don't know.
During the time period, it's fair to say that we were appearing in court every couple of months on discovery, right?
Yes.
Did you ever notify the court on any of those court appearances that you were having trouble getting custody of the 6 search warrants that were issued in this case?
No.
Okay. Now, you talked about having meetings, discovery meetings. Tell us what those are.
You know, at various points, probably more towards the early stages, or if there's something that's significant that comes up, it would be just a meeting in relation to, this is the discovery that's outstanding, this is what I'm looking for, what's the ETA on this, when should I expect to receive this?
And are those meetings in person or on the phone?
Typically in person.
And do they take place at the DA's office or at the state police?
Well, I mean, in this specific instance, the state police is attached to the DA's office, so it's the same building. So whether it was my end of the hall or their end of the hall, I don't know.
Okay. And do you remember discussing the search warrants and the outstanding nature of the search warrants at the first discovery meeting?
Yes.
And what was the response?
That the search warrants are still ongoing, as some of those search warrants were not just July. I believe it continued into probably September of 2021 as far as the last of the search warrants. I could be off on those dates, but
so how many meetings do you have regarding discovery before the return of the search warrant in July of 2021, if that's the date?
not many. I mean, I mean, the murder occurs on July 10th, so there's not a lot of time between that. So probably 2 at the most.
2, okay. And you don't take any notes on those meetings either?
I don't know.
But I guess I can't figure out, how do you keep track? If you have this list that says all these things are outstanding and you're having these meetings because there's things outstanding, if you're not taking notes at these meetings, how do you know what people are saying and when to expect the discussion?
So if there was something that specifically was known as far as, you know, this is what's going on with this piece, and anticipated sort of ETA on return or something, then yeah, there would probably be a note about that.
All right, so let's assume that the returns came back the latest July of 2021. Let's give you 3 months, August, September, October. October of 2021. Are you asking again for the search warrant, so you still don't have?
We've been over this time period. I'm trying to figure out you went all the way through arraignment and on the number of meetings and emails back and forth. I get it, but maybe you want to cover new ground.
I'm just trying to figure out, let me ask the question. So when do you realize that you never turned over the search warrants? When do you realize that?
As far as the 2021?
Back up. When do you get the search warrant in your custody?
In my custody?
Yes.
I would say probably I became aware of it about a month ago.
In 2025?
Yes.
July of 2025 or June of 2025?
Yes.
Is the first time you became aware that you didn't turn over the search warrant?
Yes, if I had been aware earlier, then I would have turned over the search warrants.
But you had your list, right? You had your list that said 6 search warrants outstanding, right?
Yes.
You didn't ever check that off, right?
No.
So you knew they were outstanding, right?
Yes.
Okay. And then when did they get to your file?
Again, so as far as my file, they did not. Again, I became aware of it after the case had been transferred from myself to ADA Hickman.
Well, let's talk about that. What date was the case transferred from you to ADA Hickman?
I'd say probably somewhere in October or November of 2024.
2024?
Yes.
And how does the case, let me just say in general, how does the case get transferred from one DA to another? Is there a policy within the Norfolk County District Attorney's Office of what needs to get done to transfer a file?
No policy, no.
Okay. So what did you do in this case with Mr. King and Mr. Gardner to ensure that your complete file got in the hands of ADA Hickman?
So I physically took the physical file from my office to ADA Hickman's office.
Okay. And did you have a conversation with her?
Yes.
And did you tell her, hey, there's 6 search warrants that I was never able to get from Trooper Proctor?
Again, if I had known or remembered that the 6 search warrants were still outstanding, then I would have got them and provided them. So no, I did not reference that specifically.
But then at some point, ADA Hickman has to come back to you and say, did you not turn over these 6 search warrants? Say that to you?
No.
She never did?
Nope.
Did you ever have a conversation with ADA Hickman about the outstanding 6 search warrants?
Not until recently, no.
Okay, and what transpired?
Objection.
Sustained.
Well, so when you told the court that discovery was almost complete, did you know when you made that representation that the 6 search warrants were still outstanding?
Objection.
I don't know what time frame we're talking about.
I also, as I stated in my opposition, I've reviewed the FDRs on this from December and February and the other dates in 2025. That statement was never made. So, and then December.
That's why I want a date.
And October as well, when Your Honor set this for trial. So thank you.
So when's the last time you remember answering on this case?
I believe it was December of 2024.
Could it have been January of 2024?
January 2024?
Oh, so let me back that up. In January 2024, were you still representing the Commonwealth?
Yes.
Okay. And do you remember there being a hearing regarding discovery?
Not specifically, but I'm sure there were.
And do you remember, excuse me, do you remember the court asking about discovery and how the discovery was proceeding?
I'm sure it happened. I don't recall that specific date or what was asked.
Okay. And do you remember telling the court in January of 2024 that you were hopeful that by March of 2024, we could proceed forward because discovery would be complete? Remember that?
I don't.
Okay. May I approach the witness?
Yes.
It's from when? That wasn't able to get.
January of 2024.
I couldn't get. I know. Show you the request. Okay.
May I approach the witness?
Yes.
I'm going to give you the transcript of the appearance before this court on January 24, 2024, and ask you to look on page 5 and tell me, read that, the bottom of page 5 to yourself and the top of page 6.
Yes.
Does that refresh your memory as to whether or not in January 2024, you told this court that substantially discovery was complete? There might be 1 or 2 items that are outstanding, but can you get that to us?
I didn't read that portion. I was reading the highlighted portion, if I could have a moment.
Sure.
sorry, I'm not seeing what you're referring to in that
Well, do you remember
transcript.
telling the court, Your Honor, I think as far as discovery goes, we're in a fairly good position. Did you say that to the court?
I may have.
Look at lines 16, 17, and 18 on the document that's in front of you, Ms. Lally.
And what page, Ms. Attorney
Page
Cappuccio?
4, lines 16, 17, and 18. The court asks, where are we, Ms. ADA Lally? And you say, Your Honor, I think as far as discovery goes, we're in a fairly good position. Did you say that?
Again, I'm sorry, in the transcript that you handed me, I don't see that.
Let me see, it's a different one. Do you remember, hold on, let me get this right. Do you remember telling the court, I was wrong, you were right. Do you remember telling the court there may be a couple of outstanding pieces, talking about discovery, that I'll check on, and some other pieces that I was speaking to Ms. Proctor about, but I think hopefully that by March 11th date, we should be able to proceed forward. Remember saying that to the court?
Do I remember saying that to the court? No. If
Does reading that refresh your memory that you said it to the court?
I didn't read that portion. On what page are we on?
Yes.
You can read from here over to here,
Okay.
yourself, please.
Sure. Yes, that's correct.
Does that refresh your memory? ADA Lally, that you indicated to the court that, get this exactly right, there may be a couple of outstanding pieces that I'll check on, and some other pieces that I was speaking to Ms. Proctor about, but hopefully by the March 11th date, we should be able to proceed forward. Did you say that to the court?
Well, those are two. So does it refresh my memory? No, but according to that transcript, that's what I said, yes.
Okay. And you know at that point that there were still 6 outstanding search warrants that you didn't have?
No, again, if I had known, then I would have gotten them and provided them.
Okay. But weren't we talking about search warrants on this day?
You're talking about 2022 search warrants, which were in a subsequent notice of discovery related to a cell tower dump. You were provided all of those as far as the application, the affidavit, the return, and copies of the warrants themselves.
So we're talking about search warrants,
Separate search warrants, yes.
and nothing's ringing the bell that you didn't turn over 6 search warrants?
Apparently not.
Okay. So the 2022 search warrants that we talked about in court back on January 24th of 2024. At that point, Mr. King was indicted, is that right?
Yes.
Was Ms. Gardner indicted?
Yes.
All right, so what process did you go through to issue the 2022 search warrants after indictment?
Through this court.
I'm sorry?
Through this court.
So you went to Superior Court and asked for these search warrants, is that right?
Myself personally, no.
Well, did you notify defense counsel that you were asking for search warrants in a case where a client had already been indicted?
No.
Do you know whether or not there's an obligation on behalf of the district attorney's office to notify defense counsel post-indictment if you're moving to request additional search warrants?
They weren't search warrants that were pertaining to the defendants. They were.
Do you know whether or not there is an obligation on behalf of the district attorney's office, you specifically, to notify defense counsel if you're seeking search warrants after indictment?
Objection. If this is a legal, yeah.
Sustained.
Thank you.
So in any event, we're talking about search warrants in January of 2024. You don't say anything about the search warrants that are still outstanding, those 6. And you tell the court there's only a few things that are outstanding then, is that right?
Yes.
Okay. And then we come back, we suggest March and we come back in March, is that right?
I believe so, yes.
Okay. Then in March, do you tell the court, Your Honor, as far as discovery goes, we're in fairly good position. In regard to that, I believe that was turned over just prior at the last date, so there may be a couple of other additional items of discovery that I need to get and turn over, but otherwise, I think we're in a fairly good position. Did you say that to the court, sir?
Again, I don't.
Finish, Your Honor.
Yes. These transcripts in the FTR, what's on the FTR, what was said by whom, when, is all a matter of public record, and we can look at the FTR and get it. So specific quotes and what was said, what was represented, that's part of the record, and we can see that.
I just have to set it up so I can ask the question that I want to ask, Judge.
Great.
Thank you. So after having made that representation to the court, did you do anything to get the 6 search warrants?
No.
What were the outstanding matters as far as you understood back in March of 2024?
I don't recall exactly what we were talking about on a court date in March of 2024.
Do you have any notes that would refresh your memory as to what was outstanding at that point?
I might.
And would they be in your file?
If they were anywhere, that's where they would be, yes.
Okay. Now, other than the discovery motion that we filed, did we also file a pretrial conference report in this case?
That I don't recall.
Okay. But you understand normally we file a pretrial conference report where you agree to give me what I'm asking for, and we agree to file motions on stuff we can't agree on. Is that typically how it goes?
Yes.
Okay. And you don't remember signing a pretrial conference report? Not that you didn't, you just don't recall.
I don't recall every pretrial conference report I've signed.
Okay. And then we talked about the meeting with the state police. Did you have any meetings with the Milton police regarding outstanding discovery?
In-person meetings? No.
Did you send the Milton police the same type of discovery request that you would have sent to the state police?
Yes.
And did you follow up with the Milton police the same way that you say you followed up with the state police?
Yes.
And did you follow up specifically with Lieutenant Collins?
Yes.
And so what, in your mind, was outstanding on the Milton discovery that you were communicating with Lieutenant Collins regarding?
At what time?
Let's start at the beginning.
Again, it's the same type of information that you asked about before, as far as reports or photographs or any material that they might have pertinent to the case.
So whatever the Milton police turned over to you, would you have kept notes of that somewhere?
Yes.
Would there have been emails back and forth between you and Milton about what transpired?
Yes.
Okay. Did you have any trouble getting information from the Milton Police Department?
No.
When you asked for things, did they return your email and give you what you're looking for?
Yes.
Were there any reports from the Milton Police Department that you say you didn't have before you turned the case over to ADA Hickman?
There was one report, yes.
And what was that report regarding?
Mr. Turner.
I'm sorry?
Mr. Turner.
And what about Mr. Turner?
There was a report in the materials that ADA Hickman turned over in 2025 that was, I believe, offered by Detective Sergeant Clifford Murphy pertaining to Mr. Turner that I had never seen before.
Okay, and do you know why that wasn't turned over by the Milton Police Department?
No.
Did you go down to the Milton Police Department and look through their file?
No.
At any point in time when you were representing the Commonwealth, in this case, did you go down to the Milton Police Department and look through their files?
No.
Is that something that you would normally do in a homicide case? Go to the police officer's office and ask for the file?
At what point in the case?
At any point.
Typically, that would be something that I would endeavor to do closer to trial.
Closer to trial?
Yes.
So how could you make sure your obligation was satisfied if you're not meeting with the police until right before trial?
It's an ongoing duty and obligation that extends even beyond a trial.
Right, that's not my point. My point is, if you're not meeting with them and you're not going through their information, how do you know you've turned everything over to the defense?
Because I've requested it and I've been given assurances or information indicating that that is what they have.
Let me ask you the same question about the state police. Did you ever go through the state police file? while you were handling the case, as opposed to making requests and even sitting down with the state police to make, face-to-face requests on an ongoing basis and all the follow-up contacts that you had? Did you ever actually request their whole file to go through it yourself?
No.
Okay.
And can you tell us, was there a policy within the Norfolk County District Attorney's Office of sitting down with police departments, whether it's state police or Milton Police, and reviewing their file prior to trial?
Not that I'm aware of, no.
Okay. So how far in advance of trial do you finally sit down and go through, let's take the Milton Police box?
It would depend, case to case, but it's something that I would probably do at least a few months ahead of trial.
A few months. And is that the first time that you put your hands on the actual box, or are you still dependent upon the Lieutenant Collins and other officers to give you what you're looking for?
Oh, that would be a time where I'm actually like, let me see the file and ensure that I have everything that you have.
Okay. And is there any prohibition to that meeting that you have a couple of months prior to trial happening right after indictment?
No, and that would be my practice now. So you're asking about sort of my general practice at the time. That would have been it at the time, but now I would do that much, much earlier in a case.
Okay. And the state police the same way? Did you sit down with them at some point and look through their file, or you never looked through their file?
No, as His Honor just asked, no, I didn't.
Okay. So I guess my question is, how did it work? Did they only look through their file and send you what you're asking for? Or did it, at any point, did they send you here's everything that we have?
My request and my ask was for everything they had. So as far as me then double checking to ensure that I have everything they have, that would be something that would occur later on. And as I just indicated, my practice now would be to do that much earlier in the case.
Okay. So when you go, in this case, you knew we had picked a September 8th trial date, right?
I was aware, yes.
Okay. So you knew the case was ready for trial on September 8th. When were you planning on sitting down with the Milton Police and going through their file?
As the case was reassigned to ADA Hickman around the time that we selected the trial date, I don't know that I had a specific plan to do that. I did have a specific plan to meet with ADA Hickman to go through the file to ensure that she had everything that was there.
So by the time she had taken over in January of 2025, you had not made any plans to sit down with the Milton Police to go through their file, is that right?
She had taken over prior to that, but no, I hadn't.
Okay, and the same with the state police, is that right?
Correct.
Okay, so when you're updating ADA Hickman, when she takes over the case, do you tell her, I've never actually seen the files, it's on my list of things to do, but I never get down there, you should get down and take a look at the files?
Not that specific, but yes.
What did you tell her?
That, during the regular trial preparation or meeting with the officers as it gets closer to trial, I would do that, but I hadn't done that yet.
Okay. So I'm still trying to understand, is there like when the police give you something, do they just email it to you, or is there like a list to say, we gave ADA Lally these documents on this date?
As far as their list?
Yes.
I have no idea what they have.
Okay. So you don't know, as you sit here today, if they have an index of all the things they say they gave to you?
I don't.
Okay. And do you, on the opposite side, have an index of the things you got from them?
It would be contained within those requests, yes.
All right, so at some point you print out all your requests and say, okay, let me just make sure I have everything here. I've been requesting something since, December of 2021. I want to make sure I have everything. Do you sit down and do that at some point to make sure everything you requested you've received?
And my general practice would be, yes, that would be as I know we're getting closer to a trial date.
Attorney Scapicchio, it's a little after 11, and we're going to be able to go until about 11:10. And then I have to break because we're going to have to do the motions to suppress on the two other matters. So we need to think about an appropriate time to break. Maybe now is a good time to break, and we need to talk about another date when we can come back and continue the hearing.
So you're on.
Okay. Attorney Lally, you can step down. Thank you. For the record, I think the defendant's general motion for relevant discovery is docket number 8 in docket number 21 CR 320. That's what we were going to mark as Exhibit 1. It's signed by you, Ms. Capiccio.
It was on behalf of Ms. Gardner.
I don't know, I didn't dig up a motion to join, but in any event, we're talking about what would be otherwise Exhibit 1. It's docket number 8 in the case, all right? Next dates. I would like to have the benefit of your comparison of the old and new, the earlier disclosed and the later disclosed, and how the various items are different.
So,
Might I ask also that the court order if they're materially prejudicial to the defendant as we explore the discovery?
Yeah, I'm not sure where your microphone is, but if you can, your mic, can you speak right into the mic?
May I also ask the court to order what is materially prejudiced if
Right.
these materials?
Right. It would be helpful to me if you're proceeding on a prejudice argument to know what it is that you contend is prejudicially late disclosed, okay? And
might take a little longer, Judge, because last Thursday, we got some additional discovery from the Commonwealth.
well, let's start in tranches. Okay, we can deal with April, and then we can deal with May.
Okay.
And if we have to deal with it in parts, we can deal with it in parts.
So you're on.
But I don't know how much time it's going to take for the parties to get together on this, and I don't know how far out we should look at a date.
And as far as the time frame for the material, how about when counsel filed the motion? Up until that point, I'm not going to.
Oh, Mr. McGee is suggesting that which of the documents produced as of the time you filed the motion for sanctions or to dismiss,
Okay.
do you now view as prejudicial? That is to say, and frankly, how you were prejudiced. Okay, this is a witness who's deceased, or we have no way of following up on this, or whatever it is. Okay.
That's only part of the other, I don't want to not meet before that.
Will be.
I mean.
I would like you to do, a week, spend a week to try to get back and forth together on these.
Sure.
There's a long list, but it's not voluminous. You can deal with it. You've been through these documents. Each side has been through the documents.
Sure.
So hopefully you can come up with a list. And, I'm happy to give you a date when we can continue this hearing.
So you're on. How far out do you think we need to go?
Well, it depends on when you can get that list together. I don't know how long it's going to take for you folks to get together, but we could do later this week for continuation of the evidence. We could do the following week, I believe, on the 29th to 30th in the morning. I'm not 100% sure.
Could I bring the other parties in? I think.
Sure.
Another ADA is grabbing.
Sure.
Parties. And I know we have counsel here for another party, so.
If somebody has the transcripts of all the various hearings.
I do, Judge. I'm happy to share them with everybody.
Yeah, share them with everybody and let's.
We literally late last night.
All right, but my point is, in the next hearing, stand up and say, Exhibit A is all the transcripts of the various hearings on discovery. That's Exhibit 1, okay. And Exhibit 2 is our reconciliation between the documents, and this is the way in which they're different or new, okay. And Exhibit 3 is whatever else you want. Here's our discovery report, and here's my discovery motion, and here's the motion. You don't need a witness for that. These are all part of the record, and so there's going to be no contest as to any of that. That's just putting in the record. And then if you have specific questions for somebody, ask it. But, so I think this can be done in a much more streamlined way. And hopefully we can do it that way. How much more, what other witnesses do you anticipate?
I anticipate Trooper Proctor, who didn't join us today, and I anticipate ADA Hickman. Those are the only three that I've subpoenaed, but based on the testimony, I think we're probably going to need Lieutenant Collins as well, Judge, and maybe Trooper Telly.
All right, and how many witnesses do you think you're going to need?
Trooper Tully here, Deputy Chief Collins, and Officer Binda. regarding the Milton issues. And there's a motion to quash, and I know Your Honor's up against somewhat of a time with respect to ADA Hickman, being the predecessor counsel and now counsel of record on the case, that she can answer any questions the court can, has, that are remaining, from right where she stands.
All right.
And opposing the production of.
All right, so we have 4, maybe 5 witnesses left. So we need a day when we can do this in an efficient way. Jim, how does our calendar look?
Well, 7/29, which is a Tuesday, is particularly good.
Particularly good.
Well,
there was a reason for that. I'm trying to remember what that reason was.
Tuesday.
We have a noon lobby conference?
There is a lobby
I
conference.
have a federal case on, so.
29th is not going to work for you, okay?
How about the 30th in the morning?
We have anything on that morning?
We do not.
No?
Can we potentially push this to the first week of August?
The 30th is a problem for you?
It is. I can have on the 5th or 6th.
6th is out, 5th is a possibility, but I don't know what we have that morning.
Okay. How about
According to me, the 5th
7th?
isn't good.
That's blocked up. Let's just pull up the list for the 5th. I know I am not away that day.
Hector Calderon, the lobby.
All right, so it looks like we could do August 5th.
Just could, I know that,
Can you do that?
I can.
All right.
Does it work for?
Witness issues, August 5th? That's okay? All right.
so Judge could, I know that, Trooper Proctor's attorney is here. We did serve him in hand today. Could he communicate the new date to him so we don't have to reserve him? I don't want to go back to his home.
Morning, Your Honor. Dan Moynihan on behalf of Michael Proctor. He can be available August 5th.
Okay, good. So, 9 o'clock?
Sure.
I would like to get the agreed to exhibits, including the transcripts of any prior hearings, any prior filings that you want to draw to my attention, the reconciliation of exhibits, et cetera, in advance. So I am away the 31st and 1st. So if I have them here by first thing on the morning of the 4th, I'll read them all before the 5th, okay? So I'm not trying to create artificial deadlines for you, but I think everything will go faster if I've had a chance to take a look at the agreed to exhibits, okay?
Absolutely, Your Honor.
All right.
Thank you, Your Honor.
Thank you, Your Honor.
9 a.m.
We'll take a 15-minute break and reconvene 11:30 on the motions to suppress.
Thank you, Your Honor. Thank you.
All right.
Jimmy, do we have Zoom going? Sorry. Do we have Zoom going?
Yes.
Yeah, thank you.
I put one back.
Okay.
Hello, folks. Grant Smith Ellis here. I am going to stay with you for a little bit because I'd like to see if this 11:30 motion to suppress hearing is going to be related to these cases as well. Let me check the docket. Again, my name is Grant Smith Ellis. I'm going to turn this, hold on, I'm going to turn this down. All right, so we are on a 15-minute recess. That was quite an interesting day. I'm going to explain to you what I think happened, and then we're going to come back at 11:30 and see if these motions to suppress are also relevant. Now, I am going to come up on the screen right now. Give me 1 second. Look at me. I'm a little towel. Oh goodness. Oh goodness. What if I just hang out right here? Hold on. Hey, that's me. I'm a towel. Look at me being a little towel up on the Zoom screen. I'm a little towel. Hello. It's so good to see you all. I'm on the TV. Look at me. I'm a towel. All right, so here's what's going on. These are 4 unrelated criminal cases to the John O'Keefe and Karen Reed case. But ADA Adam Lally just took the stand because what's going on is that ADA Adam Lally was involved with the prosecution of these 4 unrelated cases. And Michael Proctor and Brian Tully and other troopers on the Norfolk DA's assigned state police unit were involved. And there was at least one instance where Michael Proctor withheld a bunch of search warrants from Adam Lally in one of those cases. But I also want to be clear that Adam Lally was, Brian Tully was the person who took a 15-year extraction of Lindsay Gattani's phone in the context of the Aidan Kearney case on April 24, 2024, and released that extraction completely unredacted, including pictures of Lindsay giving birth to Aidan Kearney's lawyer. And then Aidan then apparently gave it to a guy named Jason Broyles, who pretends to be a woman online named Haley. And then that guy started writing about it, apparently to help Kate and Tully, because I believe Broyles was a long-term undercover mole for Kate. But anyway, Brian Tully, this hearing today just showed that there's a clear pattern of discovery violations and this kind of behavior by that state police unit. And I'm telling you, it's not just going to come out like this. It's going to come out over and over and over again. That's why this unit is getting moved around. It's not just the Sandra Birchmore cover-up. You have to remember, this was the same state police unit that investigated the cover-up of Sandra Birchmore's murder. Okay, you see what I'm saying? Okay, so this is a big deal. Very, very big deal. Very, very, very big deal. And so, thank you so much, Colleen Henry. I appreciate it. We might just stream today, okay? If I have to replay that hearing because I got stuff going on, I'm going to do that. But it is a big deal, okay? It is a big, 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 big deal, okay? Big deal, ladies and gentlemen. It is a big deal. Hey, look at me. I'm a little towel. Oh, that's great. Okay, it's a big deal. Hold on. Let me see if I can do this. Wait a minute. I got a plan. Watch this. Hold on. I make myself. I think I can do this. Watch how efficient I am. I'm a little towel. Have you ever been a little towel? I'm a little towel. Watch this. Oh, wait a minute. No, other way, Grant. Other way. Oh, look at me. Look at me. I'm a sideways towel. Hey, I'm aligned with the, hey, I'm a sideways towel. Have you ever wanted to be, look at me. It looks like I'm actually interacting with the desk. Oh, this is incredible. Oh, this is incredible. Hold on. Let me see if I can make this perfect. All right, hold on. Look at this, ladies and gentlemen. It looks like I'm sitting here with a towel desk. Oh, have you ever seen anything like it in your life? I'm a little towel. All right, so we're going to be going until 11:30 when we're going to resume with coverage of this. But I would just like to say, for the record, that I am a towel. I think I should just be like this all the time. This is glorious. I'm a little towel. So anyway, I'm going to see if this 11:30 evidentiary motion to suppress hearing is about the same thing. But Adam Lally taking the stand there to talk about discovery violations involving the Norfolk Norfolk DA's MSP, Mass State Police Unit, is a big deal. It's a big deal. I think it's just the beginning of a lot of fallout. I don't think this is going to necessarily protect anyone who's involved with the leaking of that federal grand juror information or anything like that. I just think the two things go hand and aren't necessarily mutually exclusive. It's entirely possible that people are going to get nothing to do with the John O'Keefe and Karen Reed case in terms of the investigation of John's death. But it's entirely possible that people are going to get in trouble, one, for the cover-up of Sandra Birchmore's murder. That's that MSP unit. Two, for the grand juror leaks. Three, for related to Aidan and Karen. Three, related to grand juror leaks. People are going to get in trouble. Let's see. Three, related to these discovery violations, which is not a federal issue, but it's more of a state-level issue with the charges holding. And then four, ladies and gentlemen, well, let me just tell you, that could be even worse, because it's becoming very clear, in my opinion, that this pattern of discovery violations wasn't just at the cost of defendants, okay, ladies and gentlemen, it was, per reports, although it is unclear if any lawyer has yet figured that out. All right. So I will say, ladies and gentlemen, it's a big deal because the fallout here, okay, we have to we have to understand what the implications of this are. It's so bifurcated. It's so many different layers, because you have, as I mentioned, those siloed 4 issues, and then the reverberations from this. This is just the beginning, because the prosecutors are the people who have to actually get this information from the state police. The prosecutors and the victims' advocates and whatnot, they're the ones who end up like getting called to the stand. Like Lally just got called to the stand, and then it's like the state police who are doing weird things, or that unit assigned to the Norfolk DA, and then Lally's got to get up there and be like, okay, like it was weird. Like I think they try to like insulate the prosecutors from knowing too much. Like Sean McDonough on the interview the other day was saying, listen, we don't bring prosecutors, the former DEA agent, we don't bring prosecutors on warrant raids because then they could become witnesses. And so I think they keep a lot of stuff from Lally, but then when Lally's testifying, the act of keeping stuff from him is a discovery violation, and that's the punishment. But I also think there's going to be other punishments, because I don't think it was just keep being loose and fast, the state police unit assigned to the Norfolk DA, with discovery violations. I think Brian Tully took a 15-year extraction of Lindsay Gattani's cell phone in the context of the Aiden Turtleboy Kearney investigation, and on April 24th, 2024, leaked that extraction by hand to Aiden Kearney's lawyer with naked pictures of Lindsay giving birth on the phone as well, along with a bunch of other privileged information that Tully should no investigator in there would ever hand over. And then immediately that got handed over by Aiden, I believe, to Jason Broyles, the man who's a parking clerk who pretends to be a woman online, and Jason Broyles then started tormenting Lindsay. And you might say, well, why the hell would Kate Peter and Tully ever want to do that? And why would they want Jason Broyles to be the one writing about it? Well, maybe Kate Peter and Tully wanted certain other witnesses in the orbit of the John O'Keefe and Karen Reed case to become, what's the word here, ladies and gentlemen, lightning rods, so that people with like a lot of money or influence or, like a big house or connections, wouldn't take the heat, quote unquote, from Aiden Kearney and his followers. And if you're saying to me, Grant, why would Kate Peter do that? Kate Peter is not the type of person who would work with Brian Tully to leak naked pictures of Lindsay Gattani giving birth in order to, with Brian Tully's help in his capacity as a state police officer, just to be a lightning rod to take attention away from some of the other witnesses in the Reed case who Kate happens to know. You know what I'm saying? And would Kate have done that? Yes, in my opinion. And why do I think that? Well, let me show you this video. And a lot of people have been talking about this. A lot of people in Canton been talking about this. And I think it's for good reason, right? And you might be saying, Graham, what are you talking about? Well, listen, let's just say a lot of people in Canton came to be aware, and maybe calling it Albert and Chris Albert, or even, I don't know, I'm a little town owl. Maybe they became aware of this little video that we're going to take a look at here right below me of Kate Peter spreading a rumor a few months before Kate started using Lindsay as a lightning rod, and with Tully's help, in my opinion. And why did Kate Peter get Tully's help? Because I believe Tully and his unit in the fall of 2023 were worried about federal exposure because they covered up, in my opinion, the murder of Sandra Birchmore. So I think, people like Kate Peter gallivanting around being like, I'll help you. I'll work for Marty Kraft as a PI, which, by the way, Kate Peter did. Kate Peter worked as a PI for a guy named Marty Kraft, who was very close to Brian Tully. And this all seems to have been Kate's work on these cases, Kate's involvement in the Karen Reed case, the Aiden case. It seemed to be Kate was going to get the reward of manipulating Gretchen Voss and the Netflix producers into presenting her as the Charlotte of the internet, and then leave them holding the bag if it came out that Kate was really just covering for Tully and that unit because they covered up Sandra Birchmore's murder. And then what Tully got out of it was this rabid animal in Kate Peter, who has 7 or 8 online friends who, some of them are nice people, okay? Some of them are actually decent, the people in her life. She is not, in my opinion. But she has this rabid group of online people around her that and listen, okay, I am just a towel. I don't know anyone anywhere around the world related to anything in terms of military intelligence or intelligence or anything. But they're low level, I guess you could call them gray hat kind of hackers, okay? And what they really do is Kate it goes into Sex Anonymous meetings, and Kate catfishes predators. And that's where she got a lot of her play with, I believe, some of these state police officers, because she goes into, she catfishes predators, and then they, do stings on them. It's called, predator hunting. That's, I think, what, she's really got going on. That's why she has, networks of influence. But because of that, when you're in that world, you like, I don't know anything about like hunting, but I've seen a little bit of like the predator hunting. I think it's an important art, but you leave it to the fucking feds or the state police. You don't need to be doing it like those college kids a couple months ago who like baited a predator or beat the fuck out of them. That is counterproductive. Why would you do that? If you're going to fucking get them, you're going to compromise the core of this is that vigilantes compromise the fucking prosecution of people. Okay? And the state police, when they work with them, because they have political and personal ends, fucking compromise prosecutions. Okay? So, Kate Petergart was trying to get a little rub, okay? And then Brian Tully was trying to insulate, I believe, and that unit was trying to insulate themselves from federal liability from the cover-up of Sandra Birchmore's murder. But then I think it was a little bit more, too, because I think it was also like some witnesses in the Orbit of the Reed case, not Colin Albert, not Chris Albert, and not Lindsay Gattani, were used as lightning rods because certain people were getting a little too much attention from the Turtle Riders. And maybe, it's not that anyone had any, other than Karen, in my opinion, had anything to do with John's death, but maybe Canton's a bit like Midnight in Savannah. Maybe it's got some skeletons hiding beneath the surface, ladies and gentlemen. And maybe the people who were in the orbit of Karen and John like to do some things that they didn't want out in public, so they got a little desperate, and they were like, okay, Kate Peter will steer the narrative. You know what I mean? And then Brian Tully was like, oh, I'm worried about the cover-up of Sandra Birchmore's murder. Kate Peter will steer the narrative. Oh, Marty Kraft can help with that. You know, let's put PIs on vulnerable fucking witnesses and victims that you were supposed to be fucking protecting. You fucking cowards! And if you're saying to yourself, Grant, would Kate Peter and Brian Tully really have coordinated together to release a 15-year unredacted extraction of Lindsay Gattani's cell phone to Aidan Kearney's lawyer and then make sure it was covered in a certain way by getting Jason Broyles involved? Like, why would she do that? Why would she want to use Lindsay as a lightning rod like that? Why would Tully ever go along with it under color of law? Like, that's serious shit. That's serious shit. That's almost as bad as covering up Sandra Birchmore's murder. Thank God Lindsay lived. And fuck any one of you that was trying to do otherwise. Fuck you. Let me play this video. And now you tell me whether you think it's really out of the realm of the possibility that this unit, playing losing fast with Discovery, no! That releasing that unredacted extraction of Lindsay's phone with naked pictures of her giving birth and other information that was privileged would become a lightning rod to distract attention from Kate and Tully's friend. You ask yourself that question. Sorry, it's muted. Come on now. Come on. Oh, I don't think it's muted. It's just my headphone might have. Oh, it's not muted. I turned the volume down. 1 second. Oh, that's why I turned the volume down. Okay, hold on. I'm not someone who will listen in. You could have a Zoom running. I'm not going to listen in on it. So give me a second. I'm too respectful, ladies and gentlemen. I would never do such a thing. All right, hold on. Hold on. I gotta mute this one. All right, mute it. All right. So what I do want to turn up though is the Google Chrome. All right, here we go. Let's watch this, and you tell me whether it's possible that Kate Peter and Brian Tully did that as a distraction. Look what Kate did to Colin and Chris Albert. She spread a rumor that they sold drugs, which then promulgated around for years. No one ever talked about it before Kate spread it. She was like, in the video, she'll say, oh, I just wanted to make Aiden look dumb. Oh, really? Why did you say Chris Albert and Colin Albert sold drugs to trick Aiden? Why didn't you say, as an example, hypothetically, why didn't you say Jen McCabe sold drugs? Eyes wide open. Hold on. I realized you couldn't hear it.
This was 100% a fabrication out of my own mind. It is not rooted in reality at all. I sent this just to fuck with Aiden to prove that he does not vet information at all. He will run with any sort of gossip that bolsters his claims, and I want to prove this. So anyone who believes him should realize that a lot of this is getting sent out. I just went ahead and I emailed turtleboysports@gmail.com. I wrote, based on a movie plot. This is based on a movie plot. You could do the same thing. He would probably run with it too. If anyone gets their fake stories mentioned by this schmuck, please email me. We'll have a prize for you. Listen to this.
All right. Again, this is an honor. Like, I don't know who this person is, but I'm just going to read the email that I got out loud. All right, bear with me. Because, hi, I've been really scared to talk to anyone about this. And I know I'm not the only one. But I see you're keeping people anonymous, and I think it's important that people know. The problem that Colin Albert had with John O'Keefe was that Colin Albert sells pills and weed, and John knew about it because he lived across the street from one of Colin's friends who runs Colin. Colin's dad knows, and sometimes the drugs go through the pizza shop, from what I've heard. The whole Albert family makes money from it. I don't know, that's that's what makes it a little far-fetched. Like, you're making the Albert family relies on marijuana sales and what other pill sales? Come on, that sounds. I'm just reading the email from it, and I don't know if his Uncle Brian knows or not, but I think he probably does and explains why they're really covering it up. I have screenshots of Colin selling drugs because sadly, I have bought from him before. Well, that's interesting. That's very interesting.
So interesting.
So again, this person asked for anonymity. They will be granted it. Just to be clear, I have not said your name, and I'm not going to say your name.
Yeah, very trustworthy man.
You are
until you don't dance to what I tell you to dance.
All right, so there you go. We're going back to the Zoom hearing. You heard what you needed to hear. I'm going off the screen now. Screw you, K. Peter. You're not a towel. Also, that wasn't an accident.
You too, Jack. And Mr. Richardson, good morning.
How you doing?
Good. Sorry to keep you waiting. We had another hearing that went all morning, so we're rolling on now. So, Mr. Mead, this is a motion to suppress the fruits of a stop. Signed
Might be unrelated.
in opposition.
Hold on, I'm going to listen anyway.
How many witnesses do you have? One?
After I did get a chance to review the affidavit this morning, just confirmed with counsel that it's solely on the stop. Based on what I had seen, the motion was on the stop. There's other mentions in the affidavit to other things, but as far as the motion that's filed as motion to the stop, I do have one officer here.
Do you agree with that, Mr. Michal?
Yes, Judge. Yeah, we had a conversation.
Okay, so essentially we're going up until the stop and the question of whether there was reasonable suspicion for the stop.
Based on the yes.
Okay.
Based on the dispatch. And Judge, I had already talked to my brother. I don't know if you're familiar with the area. I don't know how you'd like to mark this.
That's beautiful.
My brother did raise concerns. There's some red and yellow that I stipulate that has nothing to do in any way, shape, or form. It's just the way it comes up in Google. Perhaps it was traffic at that time.
Yeah. So this is just for the configuration of the street, basically?
Yes.
Yeah, that's the only thing I wanted to, as far as the.
It should be exhibit one in every suppression motion. Every one by the Commonwealth. All right. So, let's mark this as exhibit one.
We pre-marked the CD already.
Two, okay then.
Exhibit one and the.
CD is one and the map will be two.
And Judge, if I may, when you're ready.
Sure, I'm ready.
With reference to the Commonwealth exhibit, I have no objection. I would just ask that, my brother plans on playing the dispatch from the dispatcher to the officer. I think what is also relevant in the case is the actual 911 call where you have the loss prevention officer talking to the 911 operator for a reason being that the 911 operator seems to be asking leading questions. There's a language barrier.
Are they both on the CD? So, what's on this?
That's just dispatch, that's dispatch. Dispatch or turret, whatever, yeah, yes.
This is turret case, this is what's coming out of the police department.
What it,
Oh, that's a shame. I wanted to watch the hearing. All right, folks, my name is Grant Smith Ellis. Hold on. I'll come back up on the screen. I appreciate the court for giving us access. I really wanted to watch those other hearings. I should put in more requests so that we can just watch the Zoom all the time, because that's a really good way to learn about court. It would be so cool if we could just watch the court all the time. Now, my name is Grant Smith Ellis. Look at me. Look at me up on the screen. I'm going to make your chat a little bit larger. I'm trying to make myself a little bit bigger today. We'll see how this works. No promises. This stream's going to end, by the way. I'm taking a 2-hour break. I'm not just going to talk for 2 hours. My plan was to go live at 1:30. That's what we're doing. I'm going live at 1:30. I'm tired. I had a lot going on today. This was fun. I appreciate you all for tuning in. You know what? You want to play a round of Tell Trivia? You want to play a round of Tell Trivia? Let's do it. You want to do it? You want to do it? One round of Tell Trivia. You want to play? Just one round. Indulge. I'm a little towel. I don't know if we're going to be able to play it this way. Hold on. How are we going to do this? We might be able to do it. I have a plan. I have a towel plan. All right. Hello. It's so good to see all of you. All right. So, my name is Grant Smith Ellis. Let me see if anyone wants to play trivia. If not, we're just going to come back later. We can either play trivia now or we can play trivia later. I know a lot of people are going to be like, that would be great. All right. Nope. The judge is not a commie. I think Adam Lally basically exposed what was going on. Actually, you know what? Let's hold off on trivia. Let's come back at 1:30, Steph. I've changed my mind on trivia. Oh, wait a minute. Dewdrop's excited. Nope, too late. We're playing one round. Too late. Nope, it's not happening. Dewdrops wants to play. We're playing. It's not an option. Dewdrops likes Towel Trivia. I like Towel Trivia. All right, so hold on. Let me make myself... I can't be that large for Towel Trivia. I got to hang out in the corner. I'm Towel Vanna White. All right? I gotta make good use of the space. What if I put myself above the comments? I'm Towel Vanna White. All right, look at me. I'm Towel Vanna White. Hey, I'm Towel Vanna White. Have you ever wanted to be Towel Vanna White? Look at me. I'm Towel Vanna White. You can call me Towel Vanna White. All right, one round of Towel Trivia. Just one. That's it. Just one. Yeah, look, I go, oh, wait. Oh, hello. I'm Towel. Look at me. I'm here. Oh, look at me. I'm back on the screen. That was fun. All right, hold on. One round of Tell Trivia. That's it. Just one. No more than one. Just one. But also, can I do one more thing? Would you allow me a moment to just play this video again of Kate Peter and allow me to make my point about how Kate Peter, in my opinion, and Brian Tully leaked Lindsay Catani's cell phone extraction? And it was confirmed by Prosecutor Ken Mello at an open hearing that it was not an accident, that was given over on purpose. Do you think it was an accident when Kate Peter spread this rumor about Colin Albert and Chris Albert selling drugs? I don't. Let's watch though.
This was 100% a fabrication out of my own mind. It is not rooted in reality at all. I sent this just to fuck with Aiden to prove that he does not vet information at all. He will run with any sort of gossip that bolsters his claims. And I went to prove this. So anyone who believes him should realize that a lot of this is getting sent out. I just went ahead and I emailed turtleboysports@gmail.com. I wrote, based on a movie plot. This is based on a movie plot. You could do the same thing. He would probably run with it too. If anyone gets their fake stories mentioned by this schmuck, please email me. We'll have a prize for you. Listen to this.
All right. Yeah, and this is an honor. Like, I don't know who this person is, but I'm just going to read the email that I got out loud. All right, bear with me. Because, hi, I've been really scared to talk to anyone about this. And I know I'm not the only one. But I see you're keeping people anonymous, and I think it's important that people know. The problem that Colin Albert had with John O'Keefe was that Colin Albert sells pills and weed, and John knew about it because he lived across the street from one of Colin's friends who runs Colin. Colin's dad knows, and sometimes the drugs go through the pizza shop, from what I've heard. The whole Albert family makes money from it. I don't know, but that's that's what makes it a little far-fetched. Like, you're making the Albert family relies on marijuana sales and what other pill sales. Come on, like that sounds I'm just reading the email from it, and I don't know if his Uncle Brian knows or not, but I think he probably does and explains why they're really covering it up. I have screenshots of Colin selling drugs because, sadly, I have bought from him before. Well, that's interesting. That's very interesting.
So interesting.
So again, this person asked for anonymity. They will be granted it. Just to be clear, I have not said your name, and I'm not going to say your name.
Yeah, very trustworthy man.
You are
until you don't dance to what I tell you to dance
Oh,
to.
he said you're safe with me. Well, I don't want anonymity. I sent you that email, you dumb motherfucker.
Okay, so let me be clear. That's Kate up in the top. That's, I don't know who that, I think that's Boomer in the middle or at the bottom. And then that's that girl from New York in the bottom third. And they all, here's what I think Kate did. You can see it. Like, that rumor spread for years. Like, I got that screenshot of Larry Foreman from like 2 months ago. It spread for years, and Kate was the first one to ever bring it up. So what my opinion of Kate Peter is that what she did was she thought she needed to like get attention off certain witnesses in the Reed case, and then also she was working through Marty Kraft to protect Brian Tully and the MSP unit related to the cover-up of Sandra Birchmore's murder. That's my opinion. Now, you can see what Kate does is she puts out this like lightning rod stuff, and it serves two purposes. One, it deflects attention from the witnesses who have more resources or money to get Kate to do things for them, in my opinion. Number two, it also is very convenient because it allows Kate's minions, who like are from her like predator hunting world, in my opinion, it allows like 7 of them to go out in public. Some of them are pretending to be Turtle Riders and Karen Reed people, including the daughter of the woman who used to date Marty Kraft, and remember, I have reason to believe Kate was able to call this woman who used to date Marty Kraft, her boss, who was a PI, and say, hey, your daughter's going out of control on Twitter. What are you doing? And so I think that person's daughter is a Kate person, and they were pretending to be a Karen Reed person and a Turtle Rider in order to advance Kate's agenda. Likewise, I think Jason Broyles, a.k.a. Haley, has been a Kate person for years. He's a mole. I think that John Barron account is Kate, in my opinion. I also think Kate's had other moles, like in Aiden's orbit. Some of these people, I think, are actually decent, so I'm not going to burn them right here. But, like, I know who they are. I know that they, like, enable Kate. I think some of them know better than to have enabled Kate, but they either are so close to her that she's either, like, giving whatever, okay? Like, however it is that she's getting these, like, proxies, like Broyles and redacted and otherwise to go out there. She's having them do this because it kills 2 birds with 1 stone. It distracts attention from certain witnesses in the Reed case who were becoming lightning rods, and then simultaneously it gains these people credibility. If you have Jason Broyles out there as Haley constantly attacking Lindsay Gattani, you think maybe Aiden and his people are going to trust Jason Broyles? Fuck yeah. And for Kate, it's like, who fucking cares? Lindsay Gattani, her children? I'm Kate Peter. I don't give a fuck. It's all about the mission. No, you're a fucking moron, Kate Peter. And you're disgusting. And Tully helping you is disgusting. And you all should go down, in my opinion, federally for the Birchmore cover-up, for what you did to Lindsay and her phone, for all sorts of things. And God willing, you will. Same thing with the grand jury leaks and Karen and Aiden. God willing, they'll be held accountable as well. Equal justice is blind under law. I love this country. I pray every single day that all of these people, Tully, Kate, Aiden, Karen, Proctor, Fanning, Yuri, I pray all of them get held accountable. I don't pass judgment on their souls. I will leave that to God. But I pray every single day that they get held accountable, because whether it was my firsthand experience watching what some of these people did, or what I've come to understand about some of these cases, the Birchmore case or otherwise, or the grand jury leaks or whatever, I want all of them to go down. And the only way to protect the justice system in Massachusetts is to cut the heads off the snake. It's a multi-7-headed dragon, okay? And you want to deal with it, you got to deal with Kate Peter, you got to deal with Aiden Kearney, you got to deal with the state police unit that enabled them, and you got to deal with all their connections throughout the Democratic or even sort of judicial or legislative or executive establishment within the state. Every agency, every police department, we need to audit all of them. Okay, somebody called Diana DeZoglio. She's a bulldog. She's a superhero. Diana DeZoglio is super towel. Okay, so allow me to say this again. Towel Nana's calling, so I'm only playing 1 round of trivia. You think I'm going to ignore Towel Nana? Not happening. I'm going to text her and say I'm calling her in 10 minutes, all right? Somebody call the auditor, and the feds. If the feds realize that Kate Peter and Aidan Kearney and Brian Tully and Yuri and all this stuff is just one microcosm of a larger web of influence throughout the police departments, the prosecutorial establishment, the legislative establishment, whatever, in Massachusetts, you are going to have your picking. Who do you want to go after? Who do you want to get? Like, these people were doing favors for people, in my opinion, having favors done for them, and they were using the justice system as a vehicle to accomplish their various private ends. It's sick, it's dangerous, it's very concerning. But yes, all right. So I am going to take my break, okay? And I can't just ignore Towel Nana. That's literally heresy. We're coming back at 1:30 or 2 p.m. We're playing one round of Towel Trivia. I have pontificated a lot. God bless the United States of America. God bless the DOJ. Please bring justice to these vulnerable people. I've done everything I can. I'm very tired. You can see it in my body. I'm exhausted. I'm trying as hard as I possibly can, but I need some help, and I think we're moving in a good direction. These victims and these vulnerable people need some help. They don't need the Kate Peters of the world or the Brian Tullys of the world trying to use them as proxy for different agendas. We need just pure, unadulterated, blind, juridical imposition of moral standards. If we don't have that, we're going to lose this country. And the Democratic supermajority in Massachusetts didn't really enable this. They just became part and parcel to it. Because when they didn't like someone, they knew that you had a Aidan Kearney out there or whatever to go deal with them. And when they needed somebody investigated, you had a Marty Kraft or a Kate Peter out there to run these ops. They're very low-level fish in a very, very big pond. But the point is, in Massachusetts, they got away with it because they had the right friends, in my opinion, for a long time. This is a GOP DOJ. It's like a new sheriff in town. I love U.S. Attorney Leah Foley, not in a romantic way. I don't even know her. I've never talked to her. It's just this, if I can correctly, inductively interpolate what is going on, this is the greatest U.S. attorney we've ever had. People can critique President Trump for some of his appointments to the guy in New York, the Northern District, Ali Haba. Although I like Ali Haba. I think she's kind of like she shoots from the hip, but like when you shoot from the hip on a serious thing, it's very important. You can critique President Trump all you want for his appointments. He has picked some great U.S. attorneys, okay? And U.S. Attorney Leah Foley hasn't kind of like arrived on the stage yet, but I can see where this is going. And U.S. Attorney Leah Foley is going to become like, it works perfectly in the politics of it all because Josh Levy, the former U.S. attorney, is suing President Trump. So it's like a showpiece investigation to get Karen and Aidan Levy and the leaker and whatever. That's a showpiece. One investigation is a showpiece out of this. But you add in the Sandra Birchmore cover-up, which I'm sure U.S. Attorney Leah Foley's onto. You add in the state police to that cover-up. And then you add in like the phone extraction from Lindsay Gattani and Tully and Kate leaking it. Just those three. Okay, your career as a U.S. prosecutor would go down as like Rudy Giuliani when he was in the SDNY and realized how you could really use the RICO statute effectively. It laid latent from like 71 or 74 until like 84 when it really got used. You could make those three cases together are like you become like the most prominent U.S. attorney of all time. Okay, add to that the fact that you now have Aidan Kearney and Kate Peter like on a platter, and they are like, you get their phones, you get their information. They must have been talking to 1745, 360 police departments, okay? And they must have been talking to so many different PIs and so many different government officials. Maybe they didn't get a lot of play with them, but you can bring it all down. All of it. You want to bring down the Democratic establishment in Massachusetts or at least shake it to its core. Just start from Kate Peter, Aidan Kearney, and that unit assigned to the Norfolk DA and go outwards. Just go. You will splinter out and find so much. You could bring down half the state. And that's why I think these people are getting siloed. You can see it. Like Kate's a little bit desperate, in my opinion, right now because she's getting siloed. They cut her off. Like all their sources are cutting them off because they think it's hot. And the block is hot, in my opinion. So no shit, they're cutting them all off. And so Kate's going to burn all the operations. That's why she threatened Morrissey. And then the very next day, you had Sean leaking Marty Kraft's information. I like Sean, respectable patriot, but like he's a former government agent. So when I ask him, like, did Kate Peter give you that? And he's like, no. I'm like, bro, like, don't piss on my leg and tell me it's raining. Like, I'm being respectful to you when I say to you, I know Kate Peter gave you that. It's very clear that was the shot across the bow to tell Morrissey and his friends, like, she was going to burn them all. Come on. I don't like when people insult my intelligence. You want to be diplomatic about it, that's fine. Something huge is coming, and let me just tell you, I think it's going to be a juridical reckoning for everyone, because if you're the DOJ, you have an incentive to make this very fair, okay? Equal justice under law. So you bang them all. You bang them all. You bang the Birchmore cover-up, you bang the MSP who was involved in it, you bang the Stoughton cops involved with it, you bang them all. Maybe you take a few flips, but you bang them all. Of course, that's the very first thing that the feds would do. You just bang them all. And then you bang Karen and Aiden or whoever for the leaks, the grand juror leaks. You bang Levy if you can. I mean, if President Trump really wants them to do it, they could bang Levy over this. When bang is a word for like get. Like it's so much, and if you move on it all, then you look like you're equal-handed. You're the only person in this situation, maybe other than Little Towel, who can be equal-handed. And it was summarized when I said earlier. That these people, just because they went after Karen Reed in a way that was, on the whole, like, the investigation was fine, doesn't mean that they're good people. And people can't understand that. And, like, I'm not, please, and I'm casting dispersions in some sense, in my opinion, not just on Karen and not just on the state police unit, but also on Aiden and Kate Peter. Like, all the people who got involved in this proxy war ended up doing things that were very bad, and I think they felt above the law because they were in the orbit of different people who were very connected. But in order for our justice system to maintain its integrity and credibility, it has to enforce this all in an equal way. So grand juror, Aiden, Karen, cover up of Birchmore's murder, leak of Lindsay Gattani's phone with naked pictures of her giving birth under the color of law intentionally by a state police trooper. All of this, ladies and gentlemen, ties in together to one big thing. Okay, the hedgehog knows one big thing, and the little towel knows one big thing. This is a sacred justice system, sacred. And you can only get away with doing things that are profane, or in David Yanetti's words, pornographic, when you do not feel that the justice system is worthy of respect. This country thrives and exists because of unspoken norms that are inculcated throughout precedential and statutory frameworks in our justice system. If that whole thing is short-circuited because someone's like, fuck it, I have a lot of friends, I don't need to worry about being held accountable. Like, I'll never face criminal charges. I'm Jason Broyles. I know Kate. Kate knows Tully. Then the system is broken. Okay? The system is broken. It broke a long time ago. These are just microcosms of how it broke, whether it's because of the Democratic establishment, whatever, I don't care. I had no qualms talking about the church when it needed to be reformed. Okay? Archbishop Darcy was one of the people who helped me get into Boston College, one of the people who encouraged me to go to Boston College. Okay, and Archbishop Darcy was the first person to report Father Gagan to Cardinal Law, and then the church retaliated against Father Darcy by moving this lifelong BC football fan who went to seminary at St. John's down on Lake Street in Chestnut Hill. They retaliated by sending him to South Bend, Indiana, and making him the Archbishop of Notre Dame's campus. Okay. I was not afraid, and there were Jesuits who would tell me, like, this, we have to talk about this, that's how you reform it. I was not afraid to say there's something wrong with my church that I love dearly, and if we don't talk about it, you're never going to reinvigorate the new generation's faith in the Catholic Church. Now, look at Pope Francis, okay, and look at even Pope Leo. Look at this new reinvigorated sense of Catholicism throughout the world. Why? Because they weren't like, okay, we have to hide this, we have friends, we know how to make sure that people who are victimized are silenced, we know what to do. No, Pope Francis knew exactly what to do, which is why they elected him pontiff. And by the way, Pope Benedict stepped down because he was the head of the Congregation for the Doctrine of Faith in Germany in the 80s, and he moved around the damn priests personally. They were going to get him on crimes against humanity. They were literally going to indict him. So he stepped down as a compromise to avoid the International Criminal Court having to go into the Vatican. And Pope Francis knew what he was doing. he intentionally was trying to say to the sort of more like corrupt elements of the church, no. Like, if the goal is making the church like something to be proud of, if you want more people to be involved, if you want people to believe in the mission of Jesus, which is the whole point, like setting aside the word of man and everything else, self-interest, politics, if you want people to think about like doing unconditional acts of service and loving their fellow man and not allowing like the money changes in the temple to undermine the sacred nature of it all, then you have to be willing to stand up. You have to be willing to say what has happened within the institutional church is wrong. And if we want to reinvigorate public confidence in the church, we have to address it directly, head on. We have to reform ourselves, and we have to be proud of the fact that from the ashes of this horrific situation, which was the church abuse scandal, we have shown that Catholicism can turn inward and revitalize itself because it's willing to address its ills. And you know who hasn't been able to do that yet? I think they're working on it. The state police. And you know who hasn't been able to do that yet? Like the edifice in the orbit of Kate Peter and Aidan Kearney, until the feds forced them to. The feds bumped all of them. This is law enforcement. This is investigatory agencies. This is intelligence agencies on the state level and local level. They got bumped by the feds. They all knew it. Everyone but Kate Peter, I think, figured it out very quickly that it was a bump. It was a bump by the feds when they released that leak about the grand juror being tied to the Karen Reed case because they were shaking stuff out of the trees, like Sean was saying, Sean McDonough, the former DEA agent. And what fell out of the trees, I promise you, people, if you're in law enforcement, this is my opinion, or you're in intelligence, you immediately know what happens when they shake the tree. That means shut it all down. Shut it down, burn it, shut down the station, get the people out of there, pull it. You pull everything. You shut down the op. You just shut it all down because it's too, like, that's what you do. That's a burn notice. So I think they're shutting down all their ops, not Kate and Aidan, but the people around them. They're shutting down their ops. Everybody knows that at this point that was a bump, and that if it's a bump, everyone was being monitored. So if you're police officers, okay, you have no protection with Signal. You have no Pegasus, Brad. You have no protection with plain text. You have no protection with your comms. The feds you cannot escape them. Okay? So what are you going to do? You're going to go meet Kate Peter in person? Listen, I think even like the Alberts and some of these people, like, why is John DePetro getting photographed with Brian Albert? You think maybe after the witnesses hired that PR firm and got like pushed Kate away, Kate started following around the witnesses to make sure that they didn't talk to the wrong people without her permission? Come on, I'm not an idiot. Come on. You have to see the larger picture, folks. You have to see the larger picture. And there's a point here. Let me play back my replay. Started falling around answers. Okay, you have no protection with Signal. You have no protection. Oh, right. So as much as these people think they're the tortoise, bro, like, what is it? Like Roadrunner and Wile E. Coyote? You're not. If you think that you are the Roadrunner, but you are actually Wile E. Coyote, you're fucked. That is literally Dunning-Kruger embodied. Like, you're so hubristic, you have so much hubris that you think you're chasing someone when you're being chased. So you're blindsided, you're not paying attention. You're chasing someone, but you're the one who's being pursued. Immediately, you know that you are the one who they're going after if all your contacts just shut down. Like, there are some people whose contacts like go up as shit happens. Like, because people know that they're the ones who were right about all this and we're not engaged in any of this bullshit, but we're upset about its impact on the vulnerable. Like, all of a sudden, like, your sources just jump all the way up. The people who are liabilities, everything shuts down because if you do a favor for somebody right now, I don't care if you think you're on an encrypted app, I don't care if you're in person, if you do a favor for somebody right now, you're going to get fucked, in my opinion. And they all know it. They all know it. So what do? You burn the informants or the sources or the agents. You burn Kate and Aidan, which is what's going to happen. Now, it's not going to save the people who are involved with the Birchmore cover-up from indictments, but that's what you do. You burn the agents. It's a burn notice. Yes, 100%, Tanya. If President Trump, and it's why, listen, people are like Grant. You don't agree with President Trump on everything. What do you mean you love President Trump? Well, okay, two things. One, I don't agree with every politician on anything. I don't want to. And I'm pretty sure if I met President Trump, which it's been a long time, but I'm pretty sure if I met President Trump, I'd be like, President Trump, do you think that it's healthy to just have people around you that just agree with you on everything? And he'd probably be like, no. Even some of my closest people like agree with me on like 9 of 10 things. And on the one issue where they don't agree with me, I don't get offended that they don't agree with me. In fact, they may tell me something that doesn't change my position, but that makes my position stronger because I'm listening to the other side internally in my own space. I know they have no motives. They're just telling me their different position. That helps me. That's what I think he would say. The other thing is people say, why do you keep saying this, Grant? And firstly, President Trump likes Towel Grandpa. Okay, now you love Towel Grampy, and Towel Grampy used to have dinner with President Trump once a year. Towel Mom and Towel Grampy used to go down to Mar-a-Lago and they'd have their little thing and they'd sit at the table. President Trump had no reason to do this. This man is worth so much money that he doesn't have to sit down and give anyone the time of day. Not to mention my grandfather, who was the fire chief of Newton in Massachusetts for a while, which is a very, very prominent position locally. It's a very respected position. But I wouldn't exactly say it like made Grampy a millionaire. Like he did fine. I'm not like worried that he's ever going to like go like hungry. The city gave him a good pension, but he's not a multi-millionaire. He's just a regular guy. He lives in a World War II development, in a very small town. I love that for him. He's a very quaint man. He's a small little cottage down in Wareham. I used to stay at for some time. He let me live there for a while, actually, because I was running for Congress and he wanted me to have a place, because I grew up there in Buzzards Bay and he wanted me to live there. So I lived there for like 4 months, but I quickly ended that. I love Grampy. He's a really, really good man. And Grampy likes you. Grampy used to President Trump wasn't even running for office then. President Trump was just a guy helping with a charity that my mom was running. They would sit for like 3 hours. President Trump had no reason to do this. He would sit with Towel Grampy and they would just talk about like firefighting. And then Grampy would be like, I love golf. And President Trump would be like, I love golf. Oh my goodness. And Grampy's Irish. And Grampy would tell him stories. And President Trump would just sit there laughing. And Mom would just be sitting there, chatting away. Like it was, I don't know how to explain it. It was very surreal. But if Towel Grampy gets the opinion that you are like, okay, then Grampy is even like to this day, Towel Grampy is like, I love President Trump. Now he's more politically supportive of President Trump than I am. I'd say like President Trump on some of these issues, which I'm going to explain to you in a minute. And this is why I say I love President Trump. So Towel Grampy likes President Trump. Towel Mom likes President Trump. And then also you have to understand the political context of it. And there's one more thing that makes me like President Trump a lot, which is, so during that election in 2016, and I was watching this very closely. I watched all the speeches. I watched the election very closely. I was you can ask Towel Mom, I was one of the only Democrats that predicted at the time, I'm not a Democrat anymore, the party left me. I was one of the only Democrats that predicted President Trump would win the election. Well, President Trump, I was watching closely, he never brought up, ever, any of the acts of service he did for my mom's foundation or for Grampy. Ever. Never once. He could have, especially when he was getting attacked on some things. And I'm not going to go into detail, but that made me be like, okay, this man, like, he's not a regular politician, because a regular politician would have been like having those groups up there or like being like, and some of the things he did, I thought were a little bit stunty. The press conference outside one of the debates with Bill Clinton's victims, that was good, but a little stunty. But no, he'd never brought it up. So I was like, okay, he's not a conventional politician. They would have brought it up. He didn't bring it up. All right. But President Trump, no doubt, changed the trajectory of all of this. We may have only seen indictments about Birchmore if the liberals got elected, especially Harris. She was right there. She was just part of the Biden machine. So, the Biden Democratic Party machine. So in my opinion, the best thing that happened in the course of the John O'Keefe and Karen Reed case was, and the Birchmore case and the Lindsay Gattani phone case, just in general, what cases? I don't know what I'm talking about. I'm a towel. The best thing that happened in the context of the past 12 months or 7 months was President Trump getting elected. change history for the better. I don't care what anybody says. You can tell me that you don't like some of his policies. That's fine. He's not going to go out there and tell you a lot of this stuff, but he changed history for the better, and you don't think he's going to suffer for it? Have you ever seen one person in history who didn't suffer for their sin, for like doing the right thing? So, and listen, like, he's third generation agency man, 100%, bro. So, like, anything he was doing, and Taterbug will be happy to hear this, anything he was doing around the orbit of people was for intelligence, all right? So I think he's a decent man. I really do think he's a decent man. People could smear him all you want. I think he's a decent man, and he definitely knows, in my opinion, that Epstein was Mossad. And so you have a situation where, like, he wants to use it as leverage to get Bibi to stop the war against Iran and Gaza. And Bibi was like, no, I'm going to burn you. Like, you prick. Like, who do you think you are? Like, who do you think owns the CIA? Like, Mossad, you know? So that's out. All right, I'm back. Okay, so one round of towel trivia. I can't keep talking. I have a lot to say, and I don't want to keep talking right now. Not because I don't love you all, but because I want to take time off. We're not coming back till 2:30, all right? I'm taking time off until 2:30. All right, so we're playing one round of towel trivia. You can get up to 6 points. That's it. That's all we're doing. One round of towel trivia. And the category is going to be very hard. All right, it's going to be a very hard category because I'm a towel. All right, I promise you we're doing one round. That's it. One round. No more, just one round. All right, here we go. And then we'll be back after 2:30 for our next stream. This is round 14. Play if you want. We have a lot of fun. Let's do it. I'm sorry I had to go on a soliloquy. I had things to say. All right, here we go. Here we go. The category is towels in popular culture. Towels in popular culture, ladies and gentlemen. Towels in popular culture. Here we go. Best category of all time. If I get it right and you are the first one to get it right on my phone screen, then you get 2 points. No protection with sorry about that. Text. Sorry about that. If I get it right and you are the second or subsequent person to get it right, you get half a point. If I get it wrong and you get it right, you get 2 points for this category. And if I am wrong and you get it right after that, after the first person, you get 1 point. Let's do it. Oh, it's fun, Iris. Just pick a number 1 through 4. Which TV character famously carried a towel for intergalactic travel? Ford Perfect, Marty McFly, Hannibal Lecter, James Bond. Well, I don't think any of the bottom 3 traveled intergalactically. I mean, so I'm going with number 1. It was Ford Perfect. I have no idea who the hell Ford Perfect is, but I got the point. No, good guess, Steph. Sunken grave, you're hilarious. Everybody thought it was Marty McFly except for Monica, who picks up the full point. Monica knew. Good guess, Peggy. It was Ford Perfect. I know. That was a tough one. We're only doing 6 questions. We'll pick up towel trivia later today. Allie and Bro. Bro, are you awake? Allie needs your help. Mom needs your help, Bro. All right. Who's ready for the next question? Let's make sure everybody gets a chance to answer. So far, only Monica got it right. Good guess, though, Monica. You're a super towel. Dewdrop's like, oh, no, I didn't get it. All right. Next question. What film featured a character named after a colorful towel brand? The Matrix, E.T. the Extraterrestrial, Jurassic Park, The Hitchhiker's Guide to the Galaxy. Bounty? Was somebody named Bounty? I don't know. I'm going 4. It was The Hitchhiker's Guide to the Galaxy. I don't remember the character, but I got it. Beach Nance gets the full point. Great job, Beach Nance. Ange knew it. Ange gets half point. Ruth Lang knew it. Ruth gets half point. Steph knew it. Steph gets half point. Nancy, hello, my friend. Nancy gets half point. Hello, Kelton. Hello, Selena. Allie and Rue got half a point. Thank God Rue woke up. Allie was in a little trouble there. Good job, Rue. At Dewdrops, don't worry. Just ask Kiki and Riri. I have faith that they can help you. All right, next question. Say the question twice. Okay. In which book series is May 25th celebrated as Towel Day? In which book series is May 25th celebrated as Towel Day? The Hitchhiker's Guide to the Galaxy, Discworld, Harry Potter, The Wheel of Time. Now, as far as I know, only one of these books really features towels as a motif, and I'm going with The Hitchhiker's Guide to the Galaxy. I got it. Oh, goodness, we have to watch this sometime or at least read about it. Ladies and gentlemen, The Hitchhiker's Guide to the Galaxy seems to be very centered on towels. I am thrilled. I am a happy little towel. Have you ever thought about this? There's literally Towel Day. Towel Day is May 25th. Okay, listen, we need to start marking Towel Day. We have been heathens, ladies and gentlemen. We have not marked Towel Day. I feel very bad about this. All right, hold on. The first Steph was the first one to get it right. Great job, Steph Towel. We need to create a holiday on May 25th, ladies and gentlemen. We just need to create a holiday. Root Towel gets half a point. Steph Towel got the full point. Cat Dawn knows her towels. Hello, Cat Dawn. You are super towel. Did you make instant coffee today? You'll be great, Iris. You just got to have faith. It's all about confidence, my friend. It's all about confidence. Sometimes you just got to fake it till you make it. Who else? So Cat Dawn, Nancy got half a point. Monica Nelling got half a point. Hold on, Monica. Where are you? Monica got half a point. Drops, Kiki and Riri got half a point. Ange, good job, Ange Towel. Ange got half a point. And then Allie and Bro got half a point. Rue's super towel. See, as soon as Rue woke up, Allie Towel just kicked butt. I'll play until I get my half point. Well, we're only playing 6 questions, and I'm stopping until 2:30 at the earliest. Which band released an album featuring a towel on the cover? Pink Floyd, The Beatles, Queen, Led Zeppelin. A towel. Which band released an album featuring a towel on the cover? Pink Floyd, The Beatles, Queen, or Led Zeppelin? I have no idea. I'm thinking it might have been Queen. I don't know. This is a very hard question, ladies and gentlemen. I'm going Zeppelin. It was Pink Floyd. Who knew? A lot of people went Zeppelin. I was thinking Zeppelin, you know, they like towels. It was Pink Floyd. Pink Floyd loves towels, ladies and gentlemen. They are our official band. Okay? Pink Floyd loves towels. They are our official band. All right? Pink Floyd loves towels. They are our official band. Who got it? Monica was the only one. Monica gets 2 points. Great job, Monica. And Allie Towel and Rue get a full point for getting it. That was a hard one. Yep, that's why Hank's involved. Colleen Henry, you got it. Oh, and then also I heard we're going to see pictures of LS's cats later today. I'm excited. I forgot to download them, but I have them now. Next question. I wish you were here, Sunken Grave, and you are. In which science fiction novel is a towel considered one of the most useful items for space travelers? Ender's Game. Oh, sorry. In which science fiction novel is a towel considered one of the most useful items for space travelers? Ender's Game, Neuromancer, Dune, Hitchhiker's Guide to the Galaxy. Oh, it's a tough question. It's Hitchhiker's Guide to the Galaxy. It's a book about towels. Who's going to get it? Steph. Steph Towel's been paying attention, gets a full point. Ruth gets half point. Ange gets half point. Where's Ange Towel? Where's Ange? Ange gets half point. All right. That was a tough one. That was a tough one. Oh, hold on. It says I have no connection. Come on, Towel Chat. Come on. It'll come back. It'll come back. Oh, no. Oh, no. Hold on. Hold on, little towels. I have to pull up the chat on my other phone. And the last person I got was, hold on. The last person I got was Ange. Oh, it's back. Hold on. It's back. I'm back, little towels. It's just my phone stopped loading the comments for a second. So the last person I got was Ange Towel. So who else? Wait a minute. The last person I got was Ange. All right. So then Sunken Grave, a.k.a. Ghost Towel, got their half point. Great job, Sunken Grave. You're the greatest soap dispenser this side or either side of the Mississippi. Cat Dawn gets half a point. Drops, Kiki and Riri get half a point. Monica and Nancy get half a point. All right, where's Nancy? Monica and Nancy get half a point. Allie and Peggy. Allie and Rue get half a point. Peggy gets half a point. Selena gets half a point. Who else? All right, here we go. Next question. I think this is the last one. Then I'm done until 2:30. Which character is known for always wearing a striped towel in the television series The Prisoner? Number 12, number 4, number 2, number 6. Which character is known for always wearing a striped towel in the television series The Prisoner? number 12, number 4, number 2, number 6. I've never seen the prisoner. I have no idea. I didn't know he likes wearing towels. Show me number 6. I got it right! Ladies and gentlemen, that towel got it right. That towel knows his towels. I intuitively knew it. I was like, it's number 6, which is number 4 on our list, ladies and gentlemen. Steph knows her towels. Steph knows her damn towels. Ange Towel, I'm so proud of you for knowing your damn towels. Good job, Allie Towel. I'm so proud of you for knowing your damn towels. It's okay to guess, Peggy. Nothing wrong with guessing. Good job. That was a hard one, folks. That was a hard one. And Allie Towel kicked butt, took names. Steph Towel kicked butt, took names. All right. Going into our lunch break. So remember, a new stream will start up after 2:30 or so. Going into our lunch break, we have Towel in first place, ladies and gentlemen. Towel is in first place with 5 points. I got 5 out of 6 on that round. I'm a little Towel. In second place, ladies and gentlemen, it is the one, the only Steph Towel with 3 points. Ladies and gentlemen, great job, Steph Towel. You are Steph Towel. In third place, serendipitously enough, ladies and gentlemen, we have Allie Towel and Rue rounding out the podium with 3 points. Great job, Steph and Allie, for making the early podium. In fourth place, Monica Towel, 2.5 points, charging right up there. Great job, Monica, very close to the podium. In fifth place, Ange Towel with 2 points. Great job, Ange. Sixth place, Ruth Towel, 1.5. Great job, Ruth Towel. It's also a tie. Sixth place, we have Ruth Towel with 1.5, Nancy Towel with 1.5. Great job, Nancy. And Monica Towel with 1.5. In seventh place, ladies and gentlemen, we have a 3-way tie. It is Beach Nance, Kath, and Dewdrops, and Kiki and Riri, 1 point apiece. Great job, friends. In eighth place, it's a 4-way tie. Steph Towel actually has 3.5. Pardon me, ladies and gentlemen. Steph Towel has 3.5. That's why she was in second. I forgot one of her half points. 3.5. It is not a tie. She has 3.5. In the position of honor, which is 1, 2, 3, 4, 5, 6, 7. In eighth today, we have Peggy, Selena, and Sunken Grave, a.k.a. Ghost Towel, a.k.a. the best soap dispenser on either side of the Mississippi. All right, great job, everyone. We will see you after 2:30 p.m. today. My name's Grant Smith Ellis. I'm not doing my regular outro. We're not done today. Did you like this game, though? Thank you to the folks who sent donations for Towel Lunch. Did you know you can support Towel Stream? If you want to help out, you know what? I'm a little towel. Don't worry about it. But if you want to be able to help out, you can send support for this channel. We learned a lot about Lindsay Gattani today, and she's one of the multiple victims, in my opinion, who were taken advantage of by the justice system. Please consider helping her support her fundraiser. Did you know you can go to GiveSendGo, ladies and gentlemen, .com/GEFJ, all uppercase 4. And you can support Lindsay Gattani, ladies and gentlemen. Please consider donating to her fundraiser. Folks, you've been so kind to continue sending donations, and that means a lot to me. So consider doing that as well. There's a link in the chat. Any donations go to Lindsay's third-party payee for her to be able to continue to fight for justice in a system that forsakes the most vulnerable. But let's give those people a voice. Let's help them. And you can do that with a direct donation. If you want to support Little Towel, or if you want me to send the donation to Lindsay's third-party payee, just send me a note in my Cash App, my Venmo, or my PayPal, and just say for Lindsay. If it doesn't say for Lindsay, and it's like about getting me lunch, I'm going to get lunch with it. Okay, so just please demarcate it. This is a public information service designed to educate, inform, and entertain the wider public, such as to engender cogent public discourse and ward off the usurpation of our representative forms of government worldwide. Great to see so many of you today. God bless you. I'll see you again at 2:30 p.m. Eastern, 2 hours and 15 minutes from now. My name's Grant Smith Ellis. I'm a towel. You're all towels. See you after lunch.